এখন করলে নেক্সট ম্যাটার, হ্যাঁ নিশ্চয়ই নেক্সট ম্যাটার করতে
Item number 3, sorry, item number 3, WPCT 45 of Plan 23. I am for the petitioners.
yes
That the learned tribunal passed a laborious wrong order.
laborious wrong order
Consists of 7 pages. By ignoring the dictum of the Honorable Apex Court
all right
and the Rehabilitation Council of India. My lord, the advertisement is at page 39. Page 39 is the advertisement. Page 39, my lord, D may be seen, my lord, primary school resource teacher. My lord, primary school resource teacher and special teachers is meant for handicapped students. My lord, kindly come to page 42. Qualification and everything is mentioned at page 40. D. Primary school resource teacher. I'm reading. As per the recruitment rules for the post of primary school resource teacher, notified dated 5th November 2019. The following education and other qualifications prescribed for the post: junior school certificate examination, 2 years junior basic training as approved by NCTE. My respectful submission is that, my lord, in terms of the direction of the Rehabilitation Council of India, this qualification is not there. That I will show, my lord, it is appearing at page, just 2 pages before. 36. Minimum requirement of RCA approved qualification for appointment of special education teachers. Now, my lord, kindly see, my lord, this is to inform you that the council has developed the guidelines for minimum requirement of RCA approved qualification. What is the approved qualification? My lord, kindly come to page 37. Page 37, my lord, elementary, primary, upper primary. This is the qualification, my lord, required. As per Rehabilitation Council of India's qualification, we are entitled. But the qualification mentioned in the advertisement, it against the Rehabilitation Council of India. This is my first point, my lord. Second point is that, my lord, my lord, kindly come to, my lord, page 66, my lord. Page 65 first. The guidelines for recruitment of the teachers issued by the respondent number 4, respondent number 5. Page 65 is the guidelines, my lord. It starts from page 65. The operative portion is page number 66, serial number 4. It is their own guideline, they are not following it. This is my respectful submission, my lord. Serial number 4 may be seen. 1 year B.Ed special education, 1 year diploma in education, special education. Kindly clarify the special education. Clarification. The degree diploma in special education issued by any Rehabilitation Council of India should be accepted, and degree diploma issued other than Rehabilitation Council of India need not be considered. My lord, kindly take a note, need not be considered. The petitioner number 1, my lord, applied before the authority stating that the private respondent does not qualify. My lord, it is at page.
is there any private respondent also?
My lord, yes.
What about service?
My lord, I served them, my lord, speed post. They are posted in different places on contract basis. So it was not served.
Otherwise, my lord, during the pendency of the writ application, my lord, recruitment is completed. My original application will become infructuous. This application also will become infructuous.
No, but then you say that they are recruited already.
Not recruited. They are eligible. The department says that they are eligible. We are not eligible. My lord, kindly come to page 64. The respondent authority cannot blow hot and cold at the same time, my lord. Page 64. This is the reply I received from the department. Kindly see, my lord. My petitioner name is there. S. Vijaya. Objection against. Serial number 1. Ria Nandan, degree not recognized by RCI. What they are saying, department, RCI registration is not compulsory. And in the guidelines, they are saying that RCI registration is compulsory, recognized by the RCI. This is the main reason for rejecting our claim, my lord. This is my second point.
No, RCI is not compulsory, but the direction is that it should be accepted.
My lord, no, they are saying, my lord, RCI registration is not compulsory. As per RR, hence claim is rejected. In the guidelines, they are saying that RCI registration is required. Recognition of the RCI is required.
Should be accepted.
My lord.
66, it mentions
My lord.
the degree issued by RCI should be accepted.
Yes.
And the issued other than RCI need not be considered.
Yes. Now they are saying in page 64, RCI recognition is not compulsory as per RR. My lord, they cannot go beyond the Rehabilitation Council of India's guidelines, my lord. It is constituted in terms of the direction issued by the.
What is your qualification?
I am eligible in terms of this recruitment rule which was applied under the RTA Act. Kindly come to page 69. Page 68 is my RTA application. Page 68 first may be seen, my lord.
68.
Page 68 is my RTA application. Serial number 5 and 6 may be seen. I asked for the recruitment rule. They supplied the recruitment rule appearing at page number 69 under the RTA Act. As per this RTA, this recruitment rule, my lord, my clients are eligible. But in the advertisement, some other qualification was inserted, which was not recognized by the Rehabilitation Council of India. My lord, my interim prayer was rejected by the Learned Court below, stating that I have not enclosed the recruitment rule which was there in the advertisement. My lord, page 69, my lord, is the recruitment rule supplied under the RTA Act. 68 is my application. 69 is supplied under the RTA Act. 69, my lord.
1 minute. Page 42, please come to the advertisement.
My lord.
The essentials are.
My lord. Page 42, serial number 4.
Yes.
Senior school certificate examination.
Right.
I am possessing master degree.
Master degree.
2 years junior basic training as approved by INSEAD. This is not required in terms of the
required.
In terms of the RCI.
Very well. What else? Diploma degree course in special education.
That I am possessing.
Only 2.
2.
Serial number 2.
Serial number 2.
Have this junior basic training.
My lord.
And in the recruitment rules, there is no provision for this junior basic training.
Yes, and they supplied under the RTA Act, my lord, the junior, that is not there. That is there, my lord. Page number 71, that is also there, but other qualification also mentioned. Page 71.
Page 71, JBT is required.
No. 2 years, JBT or equivalent. We are coming under the category of equivalent.
What is the equivalent qualification that you have?
Diploma in special education.
Where is that?
My lord, it is there. Page 35. Page 35 is diploma in education. My lord, today morning I searched, my lord, I got one judgment of the Honorable Apex Court passed by 3 judges bench judgment, my lord. I just got only one copy, my lord, in which it was categorically mentioned by the Honorable Apex Court. I am reading only one paragraph. This is significant in the light of just stand taken by the council to ensure that special education teachers with proper qualification as approved and registered by the council are employed by the schools. The communication issued dated so and so is read as follows. Well, and in which the Andaman Nicobar Islands stands number 1, page 97. So what I pray, my lord, let there be a status quo order. Direction may be issued upon them to file the affidavit before the learned court below, pending before the tribunal. We will decide the matter, my lord, at the earliest. If recruitment is completed, we know where, my lord. This is the judgment, my lord. Passed by the 3 judges bench.
Page 35, the certificate that you are relying upon,
My lord.
is it issued by the Rehabilitation Council of India?
It was approved, my lord.
It was approved.
Yes, yes.
Where
Yes.
do we get that?
Well, it is there, an autonomous body under the Department of Empowerment and Persons with Disability, Ministry of Social Justice Empowerment, Government of India. It is approved. With regard to that, there is no dispute. But the private respondent does not qualify because their qualification is totally different. I will show from the records, my lord. They studied
How many posts are there?
only 4.
4.
Only 4. Now, my lord, kindly come to the qualification, my lord, page 48. I will show the 3 private respondent, my lord, that does not qualify for the post. I will show from the record itself.
Here there are 11 petitioners.
11 petitioners, my lord, challenging the.
Everybody possess the.
Everybody possesses the qualification, my lord. With regard to that, there is no dispute. My lord, page
And
48.
these 3 who you have implemented as private respondents,
My
they
lord.
have also applied.
They also applied, the department published a list stating that they are eligible, we are not eligible because we don't have JBT. But as per the terms of the Rehabilitation Council of India, JBT is not required. JBT is meant for junior basic teacher, so only for the primary school teacher, not for disabled persons.
And where do we get that? It is not for disabled persons. This post is meant only for the.
It's there in the advertisement itself, my lord.
PWD, it's there.
It is there in the advertisement itself. Special education teachers means, my lord, it is only for handicapped persons.
Details of the vacancy is primary school resource teacher.
My lord,
Where is this special education mentioned?
my lord, it is there in the recruitment rule, page 71.
No, but the vacancy notification is in respect of the PWD candidates. Where from do we get that?
My lord, it is the primary school resource teacher means special teachers for the handicapped. The special teachers for handicapped only. It is there, my lord, in the advertisement it is there. Page 71, column number 2, it is there. Special education teachers teaching any type of disabled children.
Very well. Let us see what the CAT said.
My lord, prior to that, my lord, 2 documents I want to show. Page 48 about the probate respondent.
Private respondent.
My lord,
Bharat Seva Samaj.
my lord. My lord, this certificate is not valid certificate, my lord. Why I am saying? BSS diploma in early childhood special education. Early childhood means, my lord, not for primary. It's LKG, UKG students. Early childhood. This is number 1. Number 2, next page, my lord, kindly come to page 49. The Rehabilitation Council of India also issued a statutory warning stating that it has been observed by the council that children with disability are trained, served by the quacks, unqualified, non-recognized persons, professionals. If anyone found serving persons with disability without RCA certificate shall be prosecuted before the court of law under section so and so. This warning was also given by the Rehabilitation Council of India. Now, my lord, kindly come to page 50. The another private respondent, my lord. Page 50, lots you will find. And the right side, July 2011. First year is July 2011. Now, my lord, kindly turn second page. He is completing first year in 1 year. Second year is completing in 5 months. Page 51. Kindly see, my lord, July 2012. He is completing first year July 2011. Page 50. My lord, another thing is also there in this.
July 11 and July 12 is 12 months.
No, not that point. My lord, down below, bottom. Name of the institution, code and address. Bottom, my lord, we will find C68, the codes, college code.
Yes.
Bottom, my lord, got it, my lord? Code. Now kindly come to next page, my lord.
Different.
Different code.
What
I
does
failed
this
to,
mean?
my lord,
What does this mean?
the different college. Code is different. Code is allotted for one college, that code remains same. That
So
can't
1
be
year
changed.
in one college and the last year in another college. It's
Can't
not
be, my lord. Not permissible. Now, my lord, kindly come to the another document, my lord, page 53, 2. Page 52. Page 52, my lord, will find valid up to 27/9/2020. Got it, my lord? Validation. Third column. This certificate is already expired. It is to be revalidated. And they are saying rehabilitation council is not required in terms of the RR. Lordship, kindly see the judgment, my lord, I placed just now. Paragraph 40.
But this Jayapriya, page 52,
My lord.
he has this certificate under the Rehabilitation Council.
She is having, my lord, but certificate is already expired.
Lapse certificate.
Lapsed.
You
Lapsed.
can always get it renewed, isn't
Or the
it?
training is required.
Again, training is
Yes, 6-month training is she has to undergo. Then only it will be revalidated. My lord, I relied upon the Honorable Apex Court judgment. I enclosed before the learned court bill also. Here is also it is there, my lord. It is there in page number. In that judgment also, Honorable Apex Court clearly held that what is the qualification required for the teachers for special education children. Page 73 starts from page 73, the judgment. The operative portion is, my lord, qualification was mentioned at page 79 by the Honorable Apex Court judgment.
Yes.
Qualification mentioned, my lord, column number 2, preparatory stage, class 3 to 5. Qualification is mentioned. Certificate, diploma from RCA approved institution are equivalent. Now, my lord, kindly come to page 81.
But here D.Ed, DLEd, everything is required. You do not possess all those.
No, I possess diploma in education, my lord, of disability. Now, my lord, kindly come to, my lord, page 81. This judgment is applied for everybody all over India. Serial number 4. Serial number 4, it is applicable to all over India. Thereafter, my lord, page number 88. Paragraph number 58. The Honorable Apex Court clearly held that for the nature of observations made and directions issued, it is not limited to the state of Uttar Pradesh and Punjab, but it will operate across the country, all states and union territories. Page 88. Thereafter, my lord, page 89. Paragraph number 63 and 64. Now, my lord, kindly come to the impugned order passed by the learned tribunal. Learned tribunal held that we do not possess qualification in terms of the press advertisement. I say that in terms of the press advertisement, that qualification which is we are possessing, that is not mentioned in the advertisement. Purposely, I don't know why it was not mentioned. It is against the guidelines issued by the RCI, Rehabilitation Council of India, my lord. It is for the disabled children.
So in one way, you are challenging the vacancy notice, the advertisement being not in accordance with the recruitment rules.
Not in accordance with the recruitment rules, number 1. Number 2, not in accordance with the guidelines framed by the RCI and not in accordance with the judgment passed by the Apex Court. 3 points I have raised, my lord. The learned court below, my lord, failed to consider all these points and admitted my original application and direction was issued for affidavit. In the meantime, they will recruit.
No interim order was passed.
That is the reason I am before your lordship. My lord, this judgment, 100-page judgment, just I got it in the morning today.
Very well.
This meeting.
Was the original application served upon the private
Yeah,
respondent?
it is contested, my lord. Kindly see.
Contested. So you
Yes.
can always serve the learned advocate who appeared for the private respondent.
Private respondent not appeared before the
This is
Calcutta.
what we were inquiring as to whether the private respondent.
No, not appeared. Page 90, my lord, we will find for the respondent, Mr. Chaudhary
Respondent, that
appeared.
is the official respondent.
Yes, I appeared before the tribunal, so I know that nobody appeared.
What will be your submission?
My first submission is, my lord, they have challenged an interim order. The CAT has admitted the OA has called for affidavits. And my lord, it will, in fact, it is fixed on 40, I've got the case status, my lord, it's fixed on 14 September. And the reply, or they call it reply over there, the affidavit in opposition is also ready. It can be filed in a day. Now, my lords, the second point is that, so therefore, my lords, against an interim order, my lords, whatever happens in the recruitment process is always subject to the outcome. So whatever that is goes without saying. However, there is a fundamental fallacy in the case of the petitioners, that being that they have themselves participated pursuant to the vacancy notice. So they are challenging the same vacancy notice whereunder they have participated and have been declared to be ineligible. So, my lord, there is a line of judgments, my lord, that where ineligible person cannot challenge the same rules or the same notice pursuant to which he participated. His case is not that the notice is contrary to the recruitment rules. The recruitment rules and notice are consistent with each other. His case is that the recruitment rules are not in terms of the guidelines issued by the Rehabilitation Council. Now that, my lords, is a challenge which then does it lie in the face of a candidate who has applied under a vacancy notice issued under recruitment rules to then say that the rules are incorrect. And secondly, my lords, guidelines are never mandatory, my lords. Guidelines are only directory. If it was contrary to the recruitment rules, even then.
What is the stage of the recruitment process now?
Because it is ongoing, my lords. It is not that anything is going to.
When will
the process is still ongoing.
Appointment letters be issued or anything of that?
Because I don't think, my lords, anything is going to happen before 14th of September. But my lords, the CAT has rejected their prayer for interim relief on the ground that, my lords, that they did not annex the rules concerned. Now they have applied under RTI and got the rules. But I have got the rules, my lords. We have filed it. We are going to file it in our reply. But fact of the matter is the vacancy notice is in terms of the rules. So if it is not in terms of some guideline, that the CAT will consider. If it is not, the CAT can always grant them relief and private. Otherwise, regarding the certificates of private respondents, what they have annexed, that issue cannot be gone into without hearing the private respondents. So that's a private dispute. I cannot comment on that, whether these are to check whether these are the certificates, these are not the certificates.
In the affidavit in reply before the CAT, are you annexing the certificates of the private respondents or the documents according to which you found them to be eligible for appointment?
Because it has to be seen in connection with the OA. The OA,
Yes.
Their main cases against the recruitment rules. My lord, may see the original application.
So whatever right now.
It has not been filed, my lord. If that is required to be done, we'll do, my lord. It is not
Yes.
the allegation. That will be that I
No,
can.
but
tell
then
that.
at this stage only, we can mention that any steps taken in the recruitment process will abide by the result of the original application. In case
Third party right will accrue, my lord.
it will, but they are already parties. It is not that they are not parties.
Parties in the, my lord, let there be a status quo. 14th it will be decided.
No, why status quo? Status quo will not be, that will create problems.
Otherwise, my lord, they will.
Otherwise, if the
Multiplicity of litigation.
if the tribunal finds in your favor, then whatever is the result is the result. And if it goes against you, you know what is to
My
be
lords
done.
may also consider, my lords, rather than even doing that, my lords may consider the date can be preponed, my lords.
I do not think so. 14th of September is hardly a
Hardly 2
fortnight to
weeks.
go.
Yes, my lord. May not be fair upon the
Then-
tribunal.
That will not be proper. You file your reply over
Yes.
there so that it can be heard.
Yes, my lord.
That direction may be issued among.
Yes, my lord, certainly. Please issue that.
The present writ petition has been filed challenging the order passed by the Central Administrative Tribunal on 3rd August 2023, refusing to grant interim relief to the petitioners herein. Stop. Paragraph. According to the petitioners, if the appointment letter is issued during pendency of the original application, comma, then third party rights will accrue and the original application will be rendered infructuous. Paragraph. Prayer has been made to pass an order of status quo in the recruitment process. Stop. We have considered the submissions made on behalf of both the parties. Stop. The private respondents are yet to enter appearance either before the tribunal or before this court. Stop. Paragraph. It appears that the matter has been fixed by the tribunal on
14th November, 14th September.
14th of September 2023. Stop. The tribunal is requested to consider the prayer of interim relief of the petitioner on the said date. Stop. Paragraph. We only make it clear that any steps taken during the pendency of the original application shall abide by the result of the same. Stop. The learned advocate for the petitioners is directed to immediately communicate this order to the non-appearing respondents. The official respondents are directed to file their reply before the tribunal within the time as specified by the learned tribunal.
Advance copy to me, madam. Reply.
Advance copy of the reply may be served upon the learned advocate for the applicants. The writ petition stands disposed of.
I am deeply obliged.
My lords, that part of the direction where my lords have said, in the meantime, it will abide.
In the meantime,
Meaning before it is listed on 14th September. Or
no, during pendency.
my lords, when that, my lords, may be made subject to further orders, my lords. Because after hearing the, otherwise the tribunal will feel that if the tribunal will feel restrained, my lords,
Why?
because my lords are passing an order.
Yes, during pendency of
Pendency of the
the
original application.
final order will always
Very,
be,
no,
Final order is always final.
always.
whatever the
final.
lordship thinks.
I am deeply obliged.
Item number 4, WPCT 46 of 2023.
My lords, this matter, my lords, I have just been given the file, my lords, it has been filed. I think the paperwork has to be filed, my lords, very incomplete documents have been given. WPCT.
Yes, papers are not here.
No, my lords, papers, incomplete filing has been done, my lords. I mean, the paperwork, incomplete in the sense this is complete, but paperwork has to be filed
Paper book,
of the CAT paperwork.
final order has been passed by CAT.
Yes, the old matter, my lords, 2016 order, then they challenged it in review. Review has been rejected on delay. Against that or both orders, this has been preferred, but the pleadings before the CAT, my lords, appear not to have been filed, my lords. I'll file a paperwork, my lords.
No, let us dismiss it here and now.
No, my lords
Because-
cannot do that. At my request, there is no interim
No.
order.
2016 order you are challenging in 2023.
The-
And you still want
No,
a direction for filing paperwork.
Even the condemnation order is not annexed, my lords. That's why I'm requesting, let it be at my request, let it go to the next circuit, my lords. I'm not asking for any prayer relief. My lords. At my request, simpliciter, let it go to the next circuit, my lords.
On the prayer of the learned advocate representing the petitioner. Let the petitioners list this matter before the next circuit. So you are saved this time.
My lord, thank you.
Item number 5, MAT 20 of 2023 with can 1 and can 2.
So far as the private respondents are concerned, the service has been filed, but they have literally refused it. I have filed the affidavit of service enclosing all the envelopes, which I could get back from the authorities.
Mandamus appeal.
It's an intra-court appeal.
refuse, the advocate must be there in the.
If court grants me liberty, I can serve the copy to the lawyer who appeared
Yes.
before the writ. I can do. I can do. I can do.
Where is the order? Page 12?
Order is at page 12.
You were the private respondent over there?
I was not being arraigned. In my absence, the writ court was made to pass an order. And Lordship, the order which was passed.
So leave to appeal has been.
Yes, my lord, yes. Yes, my lord.
So.
To the counsel who represented the writ petitioner before the writ court,
Yes.
that liberty needs to be granted.
Service upon the writ petitioner. Respondent number,
It's one, just one, it's respondent number. 5 to 7, 5, 6 and 7.
not 4. 4
I'm
also.
sorry, it's 4, 5, 6,
Yes.
4, 5, 6. I'm sorry.
Respondent number.
4, 5, 6.
How did I start the line? Respondent numbers 4 to 7 is not complete. Stop. Learned advocate for the appellant is directed to serve copy of the applications and the memorandum of appeal and the leave to appeal upon the learned advocate who represented the writ petitioners before the trial court, before the learned single judge. Stop. Let the matter appear before the next available circuit.
Obliged.
Item number 6. Deputy one of 2021. Item number 8,
My lord,
MPPT 7 of 2023.
in this case, your lordships are indicated, this is that matter concerning that sports complex, Rajiv Gandhi Sports Complex, where my lords are indicated that because they have made a proposal for settlement for the NITCO to consider. My lords, I have received written instructions, my lords. Just, it will be placed before the board of meeting of board of directors on 30th August. HED does act, apologize, only one copy, my lords, I've got this later. I have informed Mr. Tabrez, who's not there, so my lords can go to the next circuit, my lords.
Why? I saw him in the morning possibly.
Because he had to leave for some urgent situation. Let's let it come up on in the next.
Very well, please come. A communication made by the company secretary and nodal officer within bracket court cases addressed to the learned counsel representing the appellants dated 21st August 2023 has been placed before this court. Stop. It appears therefrom that the matter regarding amicable settlement request made by the respondent herein will be placed before the board of directors of the corporation scheduled on 30th of August 2023 for final views / directions. In view of the above, the appeal stands adjourned till the next available circuit. Stop. Learned advocate for the appellant shall produce the view of the appellants before the court on the adjourned date. Do you have a copy so that this can be kept on record?
My lord, that can be.
Copy of the communication dated 21st August 2023 be retained with the records.
Yeah, একটা copy দিতে হবে। না, আমার দরকার।
Item number 10, MPPT 14 of 23.
9, what about 9?
Sorry.
না, 9টা miss হয়ে গেছে।
State of 23.
My lord, I am appealing for the applicant, my lord.
Court had directed us to file an affidavit, my lords. It has now come on record. Check.
Did you get a copy?
My lord. Lord, can you have a look to my lord's order of 21st of August first, my lord. My lord has
Yes.
made certain queries.
Yes, GB Pant Hospital, how it is functioning with the dental surgeons,
Yes.
without the dental surgeons.
Now, can you see their affidavit? And whether they have said on the other day that they have initiated process for regular appointment and all.
I said general, that is my submission. We are placing the stand on affidavit. That is why I requested for affidavit, my lord. This is the factual situation, my lord.
Regular appointment has not been done.
No,
The department is managing the works of dental surgeon through contract doctors. Contract doctors means,
or no, of NHM,
Yes.
National Health Mission and Dental
Dental
Faculty of
faculty.
ANIMS. ANIMS is
Absolutely,
also.
our department. This is not, my lord, this is absolutely wrong, because why I say my lord will accept it, that one of the incumbent, the applicant is working at Calcutta, Nicobar district. There admittedly, there is no ANIMS, no NHM, nobody is there. So this is only to save that skin, my lord, this last paragraph was added. It can't be.
No, this is a response to a factual question. How are you? My lord had posed.
My client has informed me that there is no doctor at all. One technician was there who was looking after, he died. There is nobody, she has informed me, madam. And in Calcutta, there is nobody. There is no dental doctor at all in Calcutta, in the Nicobar group of.
No,
Now, my lord, kindly come to the order of.
if I may just
order of the tribunal.
explain the affidavit, my lord. We are not, what we are, the query was whether you have on, this is a, honestly, we are saying that we are managing, these are our resources. It's a factual, how
see, on the last occasion also, we disclosed our mind that
my lords,
this is a very specialized job,
my lord,
not for any Tom, Dick and Harry to go and take care of the dental needs of the patients. Right? So now as a writ court, it will not be proper to pass direction for giving regular appointment. This cannot be done. Right? So in the meantime, why don't you permit them to continue?
Now I not kindly come to the judgment of this court. Same doctors, I approach.
I have read that judgment.
In that judgment, my lord, I approached this court because the tribunal said accepted my argument and tribunal said re-engage. I was on the point of re-engage. The word re-engage is not correct. It ought to be continuous in terms of the judgment of the Supreme Court. And this court has accepted my argument.
But then you are not continuous because your term has expired.
No, after this, they have continued me in terms of the judgment of this court. In other case, my lord, it ought to be continuous, my lord. I am just placing that.
In this case, Tripti Singh Shah,
Yes.
are you all continuing?
My lord, in that case also, we were not continuing. My lord, just have a look to the judgment of the Supreme Court, which was relied upon by the court. Kindly have a look, my lord, everything will be clear.
But then Supreme Court judgment is referred to over here.
Referred to and
Manish Gupta, yes, it's here.
referred and the court has directed to allow me to continue.
Yes.
Kindly come to paragraph number 42. Paragraph number 42. Then this court therefore holds that the original applicants would be entitled to continue in their respective posts till they are replaced by a regular selected candidate. And for that reason, the impugned order is modified only to the extent
that the original applicant writ petitioner shall be allowed to continue in their respective post, and the administration is directed to extend the period of contract of appointment and or to renew the same with effect from the date of expiry of the last extension on the same terms and condition on which they were engaged till they are replaced by a regular selection candidate. After this order, they extended it, continued it.
When did your term expire?
In that case.
In this case.
In that case, my lord, I was out of service for more than 1 year. And they have extended it in terms of the order of this court. In this case, my term expired on 28th of February 2022. I worked up to 1st of April 2022. Now, my lord, once have the judgment of the Supreme Court in Manish Gupta, my lord, if once kindly have to para 6, my lord, everything will be clear why the division bench has passed this order. Paragraph number 6 first, my lord.
Yeah.
Yes.
It says, my lord, in pursuance to the said scheme, an advertisement came to be issued in the year 2014 for appointment of teacher as guest faculty to the academic year 2014-2015 in different colleges. The writ petitioners in writ petitions preferred so and so having requisite qualification applied for the advertised position in pursuance to the said advertisement. Upon their selected by the duly constituted committee, they were appointed. After the end of the academic year, the writ petitioners were discontinued from service. Fresh advertisement were issued for the next academic year. Being aggrieved thereby, the writ petitioners approached the High Court by way of writ petition. The said writ petition was allowed by the learned single judge of the High Court by judgment and order dated so and so, thereby directing that the writ petitioners would continue to work on their respective posts till regular selections were made. It was also directed that the writ petitioners were entitled to get the salary in accordance with so and so. Now, my lord, kindly come to, so my lord, the writ court directed them to be continued. They were not in service. Fresh advertisement, they challenge it. Now, my lord, kindly come to paragraph number 12. What it meant? A perusal of the advertisement dated 24 June 2016 issued by the principal of so and so college, which is at annexure so and so, and the advertisement dated 2nd July 2016 issued by the principal of so and so college as annexure so and so of the appeal paper book would show that the appointments were be made after the candidate has gone through due selection process. Though Sri so and so has strenuously argued that the appointment of the appellant were as guest lecturer and not as ad hoc employees, from the nature of the advertisement, it would clearly be seen that the appellants were appointed on ad hoc basis. It is a settled principle of law that one ad hoc employee cannot be replaced by another ad hoc employee, and he can be replaced only by another candidate who is regularly appointed by following a regular procedure prescribed.
Thereafter, kindly come to paragraph number 13. In that view of the matter, we do not find an error was committed by the learned single judge of the High Court by directing the writ petitioners to continue to work on their respective posts till regular selection are made. My lord, on the basis of this judgment only, my lord, the division bench come to my aid. Because the tribunal said re-engage them. I said re-engagement, the word would be continue in service. And I am working from 2008, 2009, my lord. So kindly, my lord, protect my right, my lord. Up to they are, it is open to them. They can go for regular selection. I may be thrown out. I am not on that. This is arbitrary act of the state, my lord.
My lords, my submission is only this, my lords, that factual situation, my lords, department has filed an affidavit, it is before the court. Now, my lords, so far as judgment, my lords, it is, my submission is, my lords, eventually they are contractual employees. So, my lords, if that, I can't disagree with the fact that that judgment is somewhat similar in similar circumstances. However, the submission, my lords, is that eventually, my lords, there are other judgments also so far as the rights of contractual employee are concerned. It is for a fixed contractual term. So, my lords, to say that the period in between should also be considered, my lords, I cannot concede to that, my lords. That is the
No question of conceding.
and now, secondly, my lords, my second submission is this, my lords, that in the event, my lords, is inclined to pass a similar order to that which was passed in Dr. Anthony's case. In that case, my lords may clarify, my request is, my lords may clarify two things. One, that as in Dr. Anthony, it is mentioned that if regular recruitment happens, then obviously they cannot continue. I mean, it is this continuance is
This goes without saying.
that no, but it is mentioned specifically in Dr. Anthony's
We
case.
will mention
The
it.
second point is, my lords, this will not come in the way of any contractual termination because, my lords, this case, my lords, this is the employer cannot be fettered from contractually terminating the services. No, there is no right continuing mandamus that till regular appointment happens, they will be re-engaged.
The moment this line is added, your client will find out a fault or try to find out a fault.
Grateful, my lord.
So to
My lords, this
dismiss or remove,
my lords,
terminate the
that
contract.
does not appear to be the intention. But my lords, my submission is otherwise, my lords, these orders, my lords, governments eventually, my lords, why, my lords, the government is having to shrink itself from throughout the country, except here perhaps. It is because of these reasons only, my lords. If a person, government cannot.
Why don't you initiate a regular selection process?
That is, of course, there.
Then-
No, but my lords, if there is misconduct, my lords, then certainly the government is entitled
You'll
to terminate
find out
the-
something. From 2008, the petitioners are working.
There is no
In
misconduct.
2022, all on a sudden, you discontinue his service.
Very well, my lords, may not,
And they are doctors.
my lord, my lord.
They are not DRMs. There is a
My lords,
difference.
if they don't report to work, what will be done in
18
that?
years we have worked.
Of course, my lord, that goes without saying. Maybe it's my lord's silence will help us more than
Yes,
my lord saying anything on that subject. So my lord may not say anything. Is what I can say.
please come. The instant writ petition has been filed by the petitioners challenging the order passed by the Learned Central Administrative Tribunal on 31st January 2023. So, the Learned Tribunal restrained the respondents from filling up the vacant posts of dental surgeon through the impugned vacancy notice. Since there may be Since there may be a requirement of dental surgeons in the administration, comma, seeking appointment to the post of dental surgeon on contract basis. Stop. The respondents were directed to take a decision on the said representation regarding appointment of the petitioners on contract basis till regular recruitment to the post of dental surgeon is made by the administration. Stop. Next. Paragraph. The petitioners are admittedly not in service at present. Stop. Their contract period expired when
On record, my lord, expire on 28th of February 2022, but I worked up to 1st April 2022, my lord.
on 28th of
Attendance
April
register are there.
2022. But the petitioners claim to have served till 1st April 2022. Stop. Next. The petitioners submit that as it is settled law that one set of contractual employees cannot be replaced by another set. Accordingly, the petitioners may be permitted to continue in service till regular selection process is conducted by the authority. Stop. Paragraph. From the affidavit that has been filed by the administration, it appears that the post of dental surgeon is still lying vacant. Regular appointment has not been done to the post till date.
Against which the applicants were working, my lord, para 2 categorically said.
Acha, posts, regular appointment has not been done to the posts against which the applicants were serving till date. Stop. The affidavit mentions that the department is managing the work of dental surgeon through contract doctors of NHM and dental faculty of ANIIMS. Stop. Paragraph. It is noticed that the tribunal was aware of the fact that the service of the petitioners as dental surgeons may be required for the administration. Stop. The petitioners are serving since 2008 till 1st April 2022. Stop. Not renewing their contract on the plea of recruiting a separate set of contractual doctors is absolutely illegal and impermissible. Stop. Next. This court, in a similar circumstances, passed judgment on 27th July 2022 in WPCT 11/2022 within bracket the Lieutenant Governor and others versus Dr. Anthony and others. By directing the
My lord, one more writ was there, my lord, because their writ was dismissed, my writ was allowed, my lord.
with WPCT 11 we have mentioned, WPCT 18/2022. Dr. Anthony and others versus Union of India and others, wherein the court was pleased to direct the authority to continue the service of the employees in their respective posts, and the administration was directed to extend the period of contract of appointment and /or to renew the same with effect from the date of expiry of the last extension on the same terms and conditions on which they were engaged till they are replaced by regularly selected candidates. Stop. The court made it clear that the original applicants shall not be entitled to any remuneration for the interregnum if they have not served during such period. So next, as it appears that the facts of the case in the matter of Dr. Anthony and others within bracket supra is similar to the facts of the instant case. Accordingly, the court thinks it fit to direct the administration in the same lines as that of in the matter of Dr. Anthony and others within bracket supra paragraph. The administration is accordingly directed to extend the period of contract of appointment of the petitioners on and from the date of expiry of the last contract on the same terms and conditions on which they were engaged till they are replaced by regularly selected candidates. Stop. The petitioners shall not be entitled to any remuneration for the period they were out of service. Stop. The respondents are directed to take steps in accordance with the aforesaid direction at the earliest, but positively within a fortnight from the date of communication of this order.
My lord, may grant some more time. 3 weeks, my lord, at least.
3 weeks. Writ petition stands disposed of.
Obligement.
Most good.
নতুন কোনো অ্যাপিল আর ডাকবেন না, যেগুলো আগে নিয়েছিলাম যদি আজকে রিটার্নেবল থাকে তাহলেই ডাকা হবে। এই 10 হয়ে গেছে, ও একবার টাচ করা হয়েছে। হ্যাঁ,
Map 14 of 2023.
তাহলে তো ঠিক আছে।
I am appearing for the respondent. Madam.
My lords, in this case, my lords, this is a MAT appeal, my lords, challenging the order of the learned single judge.
Yes,
My lords, the employee, the person in the employee in question, that is the writ petitioner, my lords, was initially employed with the Panchayat. And before in the Panchayat, my lords, in fact, this order has been perhaps the learned single judge erred in not considering, while in the Panchayat, my lords, there was an order rejecting his request for absorption or regularization. Now, subsequent to that, what happens is that these employees are transferred to the PBMC, the Port Blair Municipal Council. Admittedly, there is no post against which they are not against any sanction post. The appointment order issued by PBMC makes it very clear. Now, after this, what happens is, my lords, that they file a writ petition seeking regularization. Now, my lords knows that regularization cannot be granted if they are not appointed against a sanction post. That, my lords, is are all the judgments of the Supreme Court on that subject. It is settled law. Now, my lords, I'll just go one by one, my lords. The first, my
how
lord,
long will it take?
my lords,
We can finish it off today itself.
yes, certainly. Now, my lords, may first see the original order of there is an order of the labor court which is being relied upon. My lords, may see page 58, it begins.
Tell us one thing, the appointment of the petitioner in the Panchayat, was it against any sanction?
No, the prayer for absorption or regularization has been rejected so far as the Panchayat is also concerned.
There also, was it temporary?
No, he was perhaps, my lords,
Contractual.
no, my lord's point is that there he had made a specific prayer representation for absorption which was
How was he
rejected.
appointed, engaged?
It is his contention that he was engaged against a sanction post in the Panchayat.
What is your submission?
My submission is that in the PBMC, when he was appointed, it was not against a sanction post.
Then
So it
how
is not-
can an employee who was there in a sanction post be transferred to a place which does not have a sanction post?
Because my lords, his employment came, so therefore, under when his employer changes, he'll be governed by the terms of his employment under his new employer. It is not a government department. Panchayat is an autonomous institution. So therefore, my lords, if he is transferred to the PBMC, sorry, PBMC is an autonomous body. So if he is transferred to it's not a case of transfer. It is a case where PBMC is giving employment. So if PBMC is giving fresh employment.
This is not a
No, my lord, it is not a trial. My lord may just see I must answer the question immediately. My lord may see the letter, the order of appointment of PBMC. That my lords will find at page 61. My lords may have page 61. My lords may see page 61. This is 8 January 2016. I'll just read. In pursuance of the decision taken in the meeting with Deputy Director R&D and Panchayat Secretary Department, Directorate of Panchayat and others, PBMC under chairmanship of the chairperson PBMC on 24th November 2015, and as per decision taken by the council in its meeting held on 22nd December 2015, following workers attached to Gram Panchayat, Garacharma, Prothrapur, Doliganj, Garacharma 1 and Brichganj have been included in the municipal limit, and engage on muster roll under the following mentioned division of PBMC with immediate effect. So they are just included in the muster roll. So it is a case of reappointment, my lords. It is not a case of any transfer. And anyway, there are no sanction posts against which these people can be appointed in the PBMC. Now, my lords may see the first document which is being relied upon, according to me, my lords, it has no relevance, is a decision of the labor court in the case of these very employees when they were employed with the Gram Panchayat. This is at page 58, my lords. Here, my lords, the question before the court was reinstatement. So, my lords, it was not really on the issue before your lordship, but my lords may just see page 60, the award portion, that the action of Director of Panchayat, ANN Administration, Port Blair in disengaging or terminating Shri A. Subramaniam Chaukidar in lieu of monthly salary, though consolidated. So it's again contractual. From the service is neither legal nor justified. They are not permanent employees even in Panchayat, but their cases they are appointed against sanction posts. They are still contractual employees. From the service is neither legal nor justified, and the first party workman A. Subramaniam, subject to his opportunity against regular vacancy, is hereby entitled to be reinstated into service of Chaukidar under Panchayat on usual scale of salary, subject to further benefit or emoluments, as to be fixed time to time by administration with immediate effect, however, by making it clear that period of disengagement of the first party be taken notionally as period of employment or continuity, however, without any back wages and monetary benefit, since dispute was pending before the labor court. Now, my lords may have the next document, my lords, is at, my lords, page 145. This is very important, my lord. This document, my lords, has been ignored by the Honorable Single Judge. My lords, this is an order passed by the Directorate of, this is again by his earlier employer, page 145, whereas Shri A. Subramaniam, son of Adyan, was initially appointed as Chaukidar by the Gram Panchayat, Garacharma, on consolidated pay of 1,200 per month and continued his service until terminated by Pradhan on 5th June 2001. Consequent upon termination, he approached the Learned Labour Court for his reinstatement. Learned Labour Court passed an award, which I have just read, my lords. Whereas in compliance of the award passed by the Labour Court, he was reinstated in service in the same status and still continuing. Meanwhile, the applicant filed writ petition with prayer for direction upon respondent authorities for regularization of his service in the post of peon cum Chaukidar against the regular vacancy. Honorable High Court, after hearing both the parties, disposed of the matter in the matter of A. Subramaniam with following directions. I therefore dispose of this writ petition with direction upon that in the event any scheme is formulated in future wherein the petitioner may be entitled to absorption, case of the petitioner may be considered in accordance with law. Whereas petitioner Subramaniam filed another writ petition for direction upon respondent authorities to regularize his service in the post, Honorable High Court
Upon hearing both the parties, disposed of. I dispose of the writ petition following direction. In the event any scheme is claimed in future, petition may be considered for absorption in accordance with law. In the event any vacancy notification is published, petitioner shall be entitled to apply for the post, provided, however, he is otherwise eligible for the post. Whereas being dissatisfied, petitioner filed appeal before division bench with the prayer for modification of the above order passed by the single judge. Upon hearing both the parties, disposed of the matter with following modification in the said order of single judge. Operative part, we have heard Miss Anjali Nath for the respondent, and having considered the submissions of Mr. Jaipal, we feel that such an apprehension is not ill-conceived. Such apprehension is well-founded. Therefore, his order is required to be modified only to the extent that respondents will be free to frame a scheme within period of 6 months from today. However, if they choose not to frame any scheme, then they will pass an order giving reasons for not doing so, and shall communicate the same to the appellant. Whereas the department had already communicated the vacancy position of the sanctioned post of peon cum chowkidar to the administration, open advertisement was made by recruitment cell inviting applications for appointment against sanctioned post of peon cum chowkidar along with other vacant posts. Recruitment for the post of peon cum chowkidar against sanctioned vacant post in respect of Gram Panchayat was made after completing all due selection process. It is highlighted the Honorable Supreme Court has upheld, citing Secretary Umadevi, a temporary or casual wage worker is continued for long period. He would not be entitled to absorbed in regular service or made permanent merely on the strength of such continuance, and then that observation of the Supreme Court is set out. And now, therefore, under the explained position, the undersigned being appointing authority of Group C and D post is duty bound to follow provision of recruitment rules. While filling the same, applicant is at liberty to apply for recruitment if not otherwise ineligible. Applicant was never appointed against any sanctioned post. He was neither selected by following due process framed by administration, nor his name was sponsored by the employment exchange at any point of time. As such, prayer for regularization is rejected. Now, this is very significant, my lords, because after this rejection order, my lords, this order, my lords, after this rejection order of 14 January 2015, my lords, may next have page 149, where, my lords, this order is challenged. Now, this was not discussed at all in the learned single judge's order, because the learned single judge has proceeded on the basis that he had a right when he was with the Panchayat. So therefore, that right should be given to him when he is working in PBMC. Now, my lords, may see this order at page 149. The writ petitioner herein was working as chowkidar under respondent number 3 on a consolidated pay of 1200 per month. His engagement was terminated, and in terms of award, he reported to duty. On 22nd December, he filed representation for regularization. Further case is that on 23rd March 2011, respondent authorities published vacancy notice for 31 unreserved post of peon cum chowkidar. Petitioner filed writ petition. It came to be disposed of with direction that in event any scheme is formulated, petitioner's candidature may be considered. It is alleged that no such scheme was framed. The petitioner again filed a writ petition, which was disposed of with similar direction was passed in the earlier, but it was stated that petitioner shall be eligible to apply provided he was otherwise eligible. In view of the rigor of the direction, and it came to be preferred mat, and it came to be disposed of with modification that respondents will be free to frame a scheme within 6 months, and if respondents choose to frame such scheme, then to pass an order giving reason for not doing so and communicating the same to petitioner. Learned advocate appearing for the petitioner argued that similarly placed daily rated Mazdoors were regularized in their post in terms of order dated 10th May 2011 issued for the Office of Municipal Council, Port Blair. The learned advocate argued that denying equal opportunity to writ petitioner, the respondent number 2 rejected his prayer for regular absorption in the post of chowkidar by making an order on 14 January 2015, which is subject matter of challenge in this writ petition. The learned advocate appearing for the respondent's administration submitted there is no merit as the matter was decided not once but twice in writ application as already filed by the petitioner. It is argued that administration did not frame any scheme, and in accordance with direction passed reasoned order, there was no scope to interfere. After going through annexure P12, which is the order which I had just placed before Lordship, I find that the authority concerned, bearing in mind the factual scenario leading to passing of direction by the appellate court, passed the order which is assailed. There can be no doubt that aforesaid authority is, that is director of RD, PRI and ULBs, passed the aforesaid order after giving every plausible reason, and this court does not find any merit in the writ application to interfere with the said order. So, my lords, the order passed by the authority saying that he was not appointed against any sanction post, that he does not meet the criteria under the recruitment rules, that he is an irregular appointment and therefore cannot be regularized, was accepted by a learned single judge of this court. Now, my lords, subsequent to this, my lords may see in the second round, the first order, my lords, is 13 December 2019, which my lords will find at page 87. Now, these orders, my lords, have been discussed by the learned single judge. Now, my lords may see this is the first order. This is dated 13 December 2019. The first part is, of course, the history. I'll not impinge on your lordship's time by going through the entire history. But my lords may then come to page 89. On December, the subsequent events which we need to fill up. On December 15, 2014, Under Secretary, Government of India wrote a letter to respondent number requesting to send status of daily rated Mazdoors. On January 14, contrary to the direction, the respondent number 2 Chief Secretary rejected prayer for regularization. Now, this is of service video order. Coordinate bench dismissed the writ petition. In the said order, factual scenario was taken into consideration that no scheme was framed. In the month of April 2015, respondent number 1 brought 6 panchayats, including Gram Panchayats, Garacharma 2, within the limit of PBMC, which is respondent number 3. Subsequently, petitioner and other similar daily rated Mazdoors started working under respondent number 3 and have been working there till date. This is now they are employed with the PBMC. Respondent number 3 adopted a resolution in a meeting held on 24 November 2015, wherein it was unanimously decided that those daily rated workers, wage workers who are in employment for years together in newly included 6 wards shall be protected and be allowed to work continuously under respondent number 3. On the strength of a resolution, Viday ordered such and such, the petitioner was engaged on muster roll under administrative branch of respondent number 3 with immediate effect, and till date has been performing his duties and responsibilities as muster roll worker. Now, petitioner subsequently made representation for regularization. Several such representation made. However, such representations were not considered, for which the petitioner took out another writ petition. The said writ petition was disposed of by coordinate bench to consider and dispose of representation and to pass reasoned order after giving an opportunity of hearing within 4 weeks from the date of communication of the order, and to communicate a copy of decision. Petitioner was given further liberty to raise before the authorities issue of similarly circumstanced people had already been absorbed, but petitioner's case has not been considered at par. Subsequently, on 14 November, respondent number 3 passed order rejecting claim for being made permanent, challenging that, my lords, this writ petition is filed. It is argued, my lords, I'll not, my lords, go through all the arguments. My lords may then come at page 93, my lords may see, this is the findings. Several questions crop up, the 4th paragraph. First, whether petitioner has lost his right to pay for regularization after order dated 11th August, dismissing the writ petition. It is seen from plain and meaningful reading of the order that the same was not passed on merits, but on a reiteration of actual matrix that no scheme had been framed. Moreover, said judgment was superseded by subsequent order, whereby respondent number 4 was directed to consider and dispose of the writ petition and to pass a reasoned order. The petitioner was by the said order given the liberty to raise the issue that similarly circumstanced people have already been absorbed, but petitioner's case has not been considered at par with those persons. Argument of the respondents that petitioner cannot take advantage of 2011 decision does not hold water. Similarly, because the petitioner was absorbed by respondent number 3 only in 2015 and started giving representations in that regard from the next year, that is 2016. It was impossible for petitioner to approach the respondent number 3 immediately since petitioner was working with Panchayat. Now, my lords, then Uma Devi is discussed. And my lords may then see that the final directions, because I am reading this, my lords, although this order has been modified by the division bench, but my lords, for the completion of records, my lords, may see, my lords, the final directions at page 97. 3rd para, hence in view of several distinguishing features between Uma Devi and present case, proposition laid down is not attractive in view of petitioner having otherwise proved his eligibility at the time of entry and having put in 24 years of service. Legitimate expectation is founded on constitutional guarantee of equality embodied in Article 14. Thus, there is no reason to negate the petitioner to further consideration by respondent number 3, since such an exercise was already completed pursuant to direction. Respondent number 3 clearly expressed his views by impugned order, however, without considering the merits of the petitioner's own case, but on a general conspectus. As such, a further relegation to the same authority would result in an injustice and would waste further valuable time for the petitioner to get the benefits he is entitled to. Thus, in view of the discussions made above, petitioner has been able to prove his entitlement on the ground of legitimate exception as well as right to equality. Accordingly, writ is allowed directing. Now, my lords may see this is the direction. Directing the respondent number 3 to regularize the service in the same similar cadre in which he is working as daily rated Mazdoor as a regular worker on permanent basis on or before January 10, 2020. Now, my lords, this was carried in appeal. The division bench, my lords may see, the order begins at page 108, and my lords will see that the direction of the learned single judge, my lords, the order is modified, and my lords will have page 118. Page 118, my lords, after discussing all the arguments, my lords will see. However, my lords will see, second para, we are not concurring with the view of the learned single judge in directing regularization without the other conditions as indicated in Uma Devi. The order impugned is modified to the extent that authority will consider the candidature in terms of the scheme framed by PBMC as one-time measure in compliance with the direction passed in Uma Devi within 4 weeks from the date of communication of this order. Now, my lords, after this, my lords may see that a decision is taken at page 122. That is the order of the PBMC, where, my lords, both the division bench's direction is considered, and my lords may see page 124. Whereas in the present, Uma Devi, my lords may see the portion of Uma Devi is also set out. I'll just come to the judgments in any event, but I'll just read this on which is the basis on which this order was passed. Question of regularization of services of such employees may have to be considered merits in light of principles settled by this court in cases referred to above. In that context, Union of India, state government, and other instrumentalities, steps to regularize as one-time measure services of such irregularly appointed who have worked for 10 years or more in duly sanctioned posts, but not under cover of orders of courts or tribunals, and would further ensure that such regular recruitments undertaking to fill up vacant posts that require to be filled up in cases where temporary employees or daily wages are now being engaged. That in the present case, petitioner was not appointed in a duly sanctioned post. Apart from not having appointed against a sanctioned post, he was appointed through the order of Learned Labour Court, within its order dated 30th July 2008 after being removed from service. Thus, the condition set in Uma Devi case that employee should have been working for 10 years or more without the cover of orders of courts or tribunals is also not fulfilled. Whereas the petitioner is found not to be eligible as per notified recruitment rules of work charge Mazdoor, as brought out in the ML case 3 judgment, the appointment of an employee should not be illegal, even if irregular, where appointments are not made or continued against sanctioned post, or where the persons appointed do not possess the prescribed minimum qualifications. Appointments will be considered to be illegal, therefore does not satisfy for regularization. Now, my lords, this is challenged by way of a writ petition. But before that, my lords, before I come to the impugned order, my lords may just have page 63 for a moment, my lords. 63, my lords, is the relevant recruitment rule of the Port Blair Municipal Council. My lords may just notice, my lords, point number 11, method of recruitment, whether by direct recruitment or by promotion or by deputation, transfer, and percentage of vacancies to be filled up by various methods. So, my lords may see 100% by direct recruitment. There is no scope at all for regularization or absorption in the recruitment rules. Now, my lords may come to the impugned order, which my lords will find at page 154. This is 12 December 22, and I'll just read. The subject matter in this writ petition is impugned order dated 25th January 22, passed by Secretary Municipal Council. By the impugned order, petitioner's claim for regularization was rejected on twofold. Firstly, petitioner has continued to work as peon cum chowkidar under cover of court orders of court or tribunal. Secondly, the petitioner's educational qualifications for appointment and was not engaged against any sanctioned post. And my lords, this entire history is narrated after that. Now, my lords may straight away come. After that, my lords, submissions of my learned senior Mr. Vinukor and learned senior Ms. Anjali Nagar recorded. After that, my lords, court has the findings are from the second last para 156. This court has carefully heard the arguments What stands out before this court is that PBMC has not been able to demonstrate before this court that post of peon cum chowkidar was not there in Garacharma 2 Gram Panchayat, or that it is not a sanctioned post. This court also notes that in no answer in terms of the labor court order clearly held that termination is illegal. Therefore, there are presumption that the post of peon cum chowkidar is a sanctioned post. The labor court found that petitioner was a workman under Gram Panchayat. The award has not been challenged till date and has attained finality. The legal status of the petitioner in the Gram Panchayat therefore cannot be questioned. PBMC cannot travel behind the award. The award passed is not an interim measure. The award cannot be equated with interim orders referred to in Uma Devi decision, pursuant to which large section of persons continue to remain illegally engaged. An award is one of conclusive findings which may involve trial by evidence. The unchallenged award is pronounced even on disputed questions. Award has become conclusive. The first ground on which the petitioner was refused regularization, that is, he was under service of interim orders, cannot therefore be sustained. Second ground was that he was not employed in any sanctioned post, is equally erroneous. The observations of division bench in the last four paragraph must be read in harmony with other portions of judgment and award and other proceedings. Lastly, Ms. Nag, learned counsel appearing for the Port Blair Municipal Council, submits petition is only one, and there are 11 others and other persons in PBMC who are waiting for results. Such number of sanctioned posts are not available to accommodate. Is of the view that HR issues PBMC cannot stand in the way, and accordingly, writ petition is succeeds, and there is a direction for absorption. Now, my lords, impugning that, my lords, this appeal has been filed. My lords, my first submission is that, my lords, admittedly, my lords, there can be no scintilla of doubt that so far as the PBMC is concerned, the petitioner was not appointed against a sanctioned post. Even so far as the learned single judge has proceeded on the basis of his status in the Panchayat. But even so far as the Panchayat is concerned, my lords, there is a direction of the learned. There is an order passed at page 145 holding that he is not, the Panchayat is saying he is not appointed against a sanctioned post. That order is upheld by the learned single judge at page 149. In the second round, the learned single judge at page 87 says that Uma Devi does not apply, but the division bench again reiterates that you have to go into the question of whether he is appointed against a sanctioned post. Now, this order of the Panchayat at page 145 and the order of the learned single judge at page 149 has not been at all considered by the learned single judge. Now, my lords, what is the, so secondly, my lords, admittedly, he is not appointed to PBMC as per the recruitment rules. There can be no quarrel as to that he does not meet the criteria under recruitment rule, that he was irregularly appointed. Now, what is the consequence of these two things? Not being appointed against a sanctioned post and not being appointed through an open advertisement process as per the recruitment rules, because he was just given employment under a resolution passed by the PBMC. So, my lords, definitely he did not appear for any open recruitment process. And it also can, and his re-engagement by the labor court is an aspect which the learned single judge has formed a view that was a final order. So therefore, it cannot be said that he was working continuously. My lords, I am not really on that point, but my lords may see the consequence, my lords, of this dual situation. My lords may first have. My lords, the first, my lords, I'll just place the judgment, my lords, in Uma Devi's case.
No, prior to that, you please show this scheme pursuant to which 176 employees were absorbed. It's dated 29th of April 2011. It's mentioned in the order of the learned single judge.
My lords, let me please check whether that is on record.
It is on record, madam.
Page number.
Which page do we
Page
get?
64, 65 and 66.
Yes, thank you. Page 64, my lords may have. No, 63 is the recruitment rule.
65 and 66.
Yes, my lord. 64. My lords may see. My lords may see PUC's letter such and such received from the joint secretary referring council's letter number such and such regarding regularization of DRMs of Port Blair, wherein it is stated that matter regarding regular has been examined and the following decision has been taken. One-time relaxation of age qualification and recruitment procedures approved to regularize 176 DRMs who have been working for more than 12 to 13 years and would have no future otherwise. PBMC shall follow the recruitment rules as well as recruitment procedure, both in letter and spirit, while making any direct recruitment in future. In this regard, the details of 176 DRMs, 87 from works and other sections, and 89 from sanitary section purely on seniority basis, seniority list for regularization against the vacancies. So this is against the vacancies, my lords. A work charge Mazdoor and sanitary Mazdoor are as unders. So my lords, this appointment, my lords may then see on the next page, 10th May 2011. My lords may see this is an order passed by the PBMC. This, my lords, lays down the terms and conditions of regularization. But my lords, it is very clear from page 64 itself that these people were appointed against a sanctioned post. That is basically work charge Mazdoor and sanitary Mazdoor. So they were appointed against a post and they had worked for 12-13 years.
What about the Chowkidar in which post the petitioner was?
There is no post of that. There is no post against which he was appointed so far as PBMC is concerned. And so far as even so far as Panchayat is concerned, my lords, the authority has held and that order has been upheld by the learned single judge in the first round, that which says that he was not appointed against a sanctioned post. In the second round, the learned single judge construed that order, but the division bench again reiterated that you have to see whether he's appointed against a sanctioned post. So, my lords, those observations in the learned single judge's order at page 87 will have to be ignored because the division bench has already modified that part of the order which says that he is to be appointed, he is to be treated as a regular appointment and against a sanctioned post. Now, my lords, if I may.
See, we think that the court took into consideration the issue of discrimination. 176 employees,
My lord,
you observe,
my lord,
but then you disregard the claim of the petitioner.
my lord. But this aspect, the division bench has said that you still have to see if he's, that is a learned single judge's view, but the division bench says you have to still see if he meets the criteria under the Uma Devi principles.
No, when you observe somebody who is there in service for more than 10 years, then the principles get relaxed to a considerable extent.
My lord,
The
so far as
recruitment
this,
rules and everything.
no, but my lord, so far as this is concerned, my lords, repeatedly, my lords, even I'll show the latest judgments, my lords, repeatedly it has been reiterated, my lords, this regularization is not the same as 1/30. 1/30 is a separate issue. In case of regularization, it has to be seen, my lords, that whether the appointment was regular, and it has to be seen whether he or she is against a sanctioned post. So, my lords, that is inviolable as per the decisions of the Supreme Court. So, my lords, and this court. Now, my lords, the division bench has, even in this case, in the earlier round, division bench at 118 says that you apply the principles and see whether under law this can be done. Otherwise, my lords, merely because someone has worked for long durations, my lords, they cannot be regularized, my lords. My lords, may I just place the judgments?
No, that is all right. See, the court's order that you referred to, the labor court's order, right? That was when he was in the Panchayat.
My lord.
Thereafter, you observe him. Not observe, you take the Panchayats within the control of the Port Blair Municipal Council. It comes within the control.
Very well.
It is not that the petitioner came here.
Very well, ma'am.
The Panchayat came within the control of the municipal council, and accordingly the service of the petitioner was treated under the municipal council. Right. Now what is to be done? So the order of the award, it becomes inconsequential.
Yes, my lord.
Now, whether the petitioner was engaged in accordance with the recruitment rules or not, that will not apply because this is a fresh body. It's a different body altogether.
My lord.
Now, what remains is whether he was engaged in a sanctioned post or not.
No, yes, my lord. That also, my lords, the order at page 145, the authority has said he was not appointed against sanction post. The Panchayat authority, his original employer, that has been upheld by a single judge of this court on 11th August 2015 at page 149. So that aspect has attained finality. The learned single judge here in the earlier round, in the second round, this is the third round. In the second round, the learned single judge says that no, because learned single judge ignores that order of the 11th August, says that takes a different view. Now that is challenged before the division bench. The division bench again reiterates that only if he meets the principles under Uma Devi that he will be given appointment. So my lords, that question again arises. So my lords, eventually, even assuming that the Panchayat is not, it's not like a subsidiary company which my lords, is being taken over. It's not like that, my lords. It is just that those Panchayat limits are being now, if they are made into municipal limits. So then in that case, it again, the appointment has to be seen. Merely because their services are being taken doesn't mean they are appointed against a sanction post, especially in a situation where originally they were not appointed against a sanction post with the Panchayat. Their case would still be better if it was a situation where admittedly they were against a sanction post in Panchayat.
How many employees are there like that of the petitioner?
My lords, it is recorded in the order of the
award.
No, in the order impugned itself, it is mentioned. The submission.
Here there is only one petitioner. 11 of them.
Yes. 11 other employees, it is mentioned. One and the other 11. 12 employees.
They never approached any employees, including the petitioner.
No, yes, 12 including the petitioner.
Who are waiting for results of the proceedings. This proceeding is sitting in the fence. And if any order is passed, then they will, yes.
No, that I am not making that. I'm not saying if legally, if somebody is entitled, everybody will be entitled. That can't be. I am not making that submission. But my lords may now consider, my lords, unless because this issue comes up again and again, my lords. In fact, my lords, my lords, I will request your lordship to consider granting a judgment on this subject, my lord.
No, but then so many judgments are already there.
I'll explain, my lord. The difficulty is, my lord, it appears that there is no, my lord, authoritative judgment. It appears in recent times of this court, my lords. It is Supreme Court may have said from time to time, but what view this court has on the subject of regularization on the issue of sanction post, my lords, that in my humble submission, because this issue is raised again and again in several cases, and there are times when, my lords, courts, because the legal issue is not agitated before the courts pass certain, this honorable court time and again passes, especially in the Andaman matters, passes a order in the interest of equity that these people should be regularized, etc. But my lords, the legal question has been left unanswered, my lords. So my lords, this, and then when those orders go up in appeal to the Supreme Court and one line SLP dismissal orders come, those judgments of the division bench are used to say that this has been upheld by the Supreme Court. But my lords, the legal question, my lords, which is subject matter of these other Supreme Court decisions, my lords, may be considered, my lords, once and for all by this court, and a judgment should be maybe considered to be passed on the subject, my lords.
Yes.
Now, my lords, the first judgment, my lords, is that of Uma Devi. My lords, I am relying upon paragraphs 47, 48 and 53, my lords. Unfortunately, this one judgment, my lords, I think was given earlier, so I only have one copy. I'll just read these 3 paragraphs and hand this over, and rest of the judgments I'm carrying sufficient copies. No, you can't give one copy to the court. Para 47, my lords, when a person enters, this is the, my lords, this is like the Bible so far as the administrations and governments across the country are concerned when they argue these cases, my lords. They repeated, my lords. Some of it may be off repeated, but I'm just doing my duty. Para 47 says, when a person enters temporary employment or gets engagement as a contractual or casual worker, and the engagement is not based on proper selection as recognized by the relevant rules or procedures, he is aware of the consequences of the appointment being temporary, casual, or contractual in nature. Such a person cannot invoke the theory of legitimate expectation for being confirmed in the post, when an appointment to the post could be made only by following a proper procedure for selection, and in the cases concerned, in consultation with Public Service Commission. Therefore, theory of legitimate expectation cannot be successfully advanced by temporary, contractual or casual employees. It cannot also be held that the state has held out any promise while engaging these persons either to continue them where they are or to make them permanent. The state cannot constitutionally make such a promise. It is also obvious that the theory cannot be invoked to seek a positive relief for being permanent in the post. It was then contended, now as Article 14 comes in, it was then contended that the rights of the employees thus appointed under Article 14 and 16 of the Constitution are violated. It is stated the state has treated the employees unfairly by employing them on less than minimum wages and extracting work from them for pretty long period in comparison with those directly recruited who are getting more wages or salaries for doing similar work. The employees before us were engaged on daily wages in the department concerned on wage that was known to them. There is no case that the wage agreed upon was not being paid. Those who are working on daily wages form a class by themselves. They cannot claim that they are discriminated as against those who have been regularly recruited on the basis of relevant rules. No right can be founded on an employment on daily wages to claim that such employee should be treated at par with a regularly recruited candidate and made permanent in employment, even assuming that the principle could be invoked for claiming equal wages for equal work. There is no fundamental right in those who have been employed on daily wages or temporarily or on contractual basis to claim that they have a right to be absorbed in service. As has been held by this court, they cannot be said to be holders of a post, since a regular appointment could be made only by making appointments consistent with the requirements of Article 14 and 16 of the Constitution. The right to be treated equally with other employees employed on daily wages cannot be extended to a claim for equal treatment with those who are regularly employed. That would be treating unequals as equals. It cannot also be relied on to claim a right to be absorbed in service, even though they have never been selected in terms of regular recruitment rules. Arguments based on 14 and 16 are therefore overruled. And then, my lord, para 53.
Don't read, only give the paragraph.
Very well. Here it is 48, 47, 48, and 53. Next, I just have one copy of this. Give the next one that ML case. Yeah. My lord, the next judgment, my lords, this deals with how the Umadevi principle is to be applied. And my lords, paragraphs 7 onwards, the principles in Umadevi are enumerated. I'm just giving 2 copies of this. This is State of Karnataka versus ML Kesri, para 7 of this judgment. The next judgment after this, my lords, is State of Rajasthan versus Dayalal. This judgment, my lords, the relevant paragraphs are 11 and 12. The next judgment, my lords, after this is the judgment in Ilmo Devi's case. This is a very recent judgment. Paragraphs 21, 25, and 26. And after this, my lords, the last judgment is Vibhuti Shankar Pandey, which is relevant para is para 3. So, my lords, my submission will be that, and this is a case of DRM, this is not a case of contractual employee. So, my lords, that this person was not appointed against a sanctioned post, either in the Panchayat or in the PBMC, and they are not appointed against regular recruitment rules, not through the regular recruitment process. And in fact, in the PBMC, it was simply by a resolution passed that to help out the employees who are working under the earlier, they were taken into consideration. And now, my lord, generally, just one other, my lords, I'll not read, I'll just place the judgments. What are the, my lord, generally the rights of contractual employees, my lord? There are a few judgments which I wanted to give. My lords, the first one is State of Rajasthan versus Poluram. My lords, here, my lords, I am relying upon. This is a very short judgment, so there is no para number as such in this. I'm just relying upon placing this for your lordship's consideration. The next judgment is Mansingh versus Commissioner Garwal. Now, here, my lords, I am relying upon para 7, 8, and 9. That I copy also. 7, 8, and 9. This is 2009. 11 SCC 448. The last judgment, Union, second last judgment, Union of India versus Arul Mozi Inyarasu. This judgment, my lords, I am relying upon paragraphs 15, 22, 23, 25. And the last judgment is State of Maharashtra versus Anita. This is, my lords, paras 14 and 15. These are the. And lastly, my lords, my lords had already seen that on 10th of August, that my lords had seen the Supreme Court's order on 14th August regarding all DRMs, my lords. That, except for the forest, my lords, that would perhaps the scheme is under formulation. So whenever that happens, my lords, that as per the Supreme Court's direction, the scheme has to be formulated by 30th of November. So, my lords, that also, my lords, that order also for completeness of the discussion, my lords, that should also be placed. The affidavit, my lords, so far as regularization is concerned, my lords will see the contents of that affidavit are set out at page 5, para 10. Now, whether this will be applicable to PBMC, that is, it may perhaps be, but the scheme has not been finalized yet. However, my lords, this definitely applies to the DRMs working in the different departments. So there, my lords, certain conditions have been laid down, but this is in process. So technically, my lords, whether this will apply, will not apply, it is too early to say, my lords, where what will be the final scheme approved by the DOPT.
So I take this into
No,
consideration.
this may be ignored, my lord. This may be
Yes,
ignored.
this may create problems
Yes,
also in the
Yes.
other matter.
Yes, my lord, it may create problems. So, my lord, my submission is that this principle that appointment has to be against a sanctioned post and that appointment has to be regular and should not be irregular has stood the test of time. Unless there is a policy and that is decided that it is to be ignored, that sanctioned post is not relevant anymore, or that and those policies are upheld by this court, then except in that circumstance, my lord, there is no scope for giving regularization where the recruitment rule doesn't provide for absorption, and here the recruitment rule is for 100% direct recruitment. It does not provide for absorption, and secondly, in a situation where, my lord, sanction post is not there. So, my lord, those are my submissions.
Very well, yes.
My lord, there were several rounds of litigation, my lord. Kindly come to page 108. The division bench earlier has taken pain, whereby the division bench considered the judgment of Umadevi, ML Kesari, Santlal, Narendra Dubey, and thereafter arrived to a finding. Now, my lord, my learned friend have not read the entire division bench judgment. I will read only the division bench judgment, my lord. Kindly come to page 108. What is, my lord? The the present mandamus appeal has been preferred against the judgment and order dated so and so, directing the PBMC to recognize the service of the petitioner under the same on similar cadre in which he is working as daily rated Mazdoor as a regular worker on a permanent basis. The matter has a checkered history. As
But
the
then, 1 minute, page 118 is the operative portion.
operative portion, but the learned division, the Hon'ble division bench arrived to a finding with regard to several aspects. Like one of the aspects, they say that in terms of the order of the tribunal, he was working, therefore.
No, that portion goes.
No, that portion, my lord, division bench already decided that.
Yes,
If my lord,
that portion goes, it has been decided
by the division bench, my lord.
by the division bench.
It's page number 109.
118, the last portion.
No, in page number 109, the division bench has decided, my lord, once come to page 109.
As regards the order, continuation in terms of orders of court.
Yes, that the court said no,
Very well, that has been decided.
decided.
What about this sanction post?
My lord, this stand first time after 4 rounds of litigation they have taken. Kindly.
No, 118, the court decides that. The division bench decides. 118, please.
My
see.
lord, all the judgments. No, the court has not decided, my lord. The court has not decided.
The order impugned is modified to the extent that the authority will consider the candidature in terms of the scheme as one-time measure.
My lord, the scheme
Right.
which was framed whereby 176 people were given regular appointment.
Yes,
Yes.
and you do not qualify in accordance with that scheme.
Yes, I qualified.
You qualify.
I
Please
qualified.
show.
Yes.
No, my lord,
No, my lord,
this is the
kindly come
para before
My lord,
that.
when my learned
No,
argument, I did
sorry,
not
I'm
discuss, my lord.
interrupting, I'm not-
You please show the.
Kindly come to page 64. Second paragraph. One-time relaxation of age, qualification and the recruitment procedure is approved to regularize this 176. If my lord read paragraph 53 of Uma Devi's judgment, education qualification was never relaxed. Here they have relaxed education and age relaxation was given to them. Now, my lord, if my lord comes to page 118, what the court says? The court says the order impugned is modified to the extent that the authority will consider the candidature of the petitioner in terms of the scheme framed by the Port Blair Municipal Council as one-time measure in compliance of the direction of the Uma Devi. So, my lord, in terms of the scheme, you have given relaxation to 176 person. And I am seeking parity.
And the 176 persons, they were engaged against regular vacancies, sanctioned ones.
They say so. My lord, here the question of vacancy did not arise. My lord, if my lord read the division bench judgment, the court says there are occasions where, because my lord, once the Uma Devi judgment passed, thereafter on 10th of December 2006, Government of India issued a notification, said that you frame a scheme and regularize the persons who are working from last 10 years. Now, my lord, division bench consider this, that no scheme was framed by the municipal, the Panchayat. There is a finding that no scheme was framed, and in the midst of it, no scheme was framed, and thereafter it was, it comes within the ambit of Port Blair Municipal Council, and they were sent to there. So we are not at fault. If my lord sees Narendra Dubey case, there what happened, my lord, at the midst of when they were working, a Jharkhand state was formed. So they did not have the 10-year service. Then the matter went up to the Supreme Court, and the Supreme Court said, you have to consider it in the, so that everybody who worked for 10 years are to be accommodated. Now, my lord, I am working from 1995. Now, my lord, whatever writ petitions I have filed, my lord, ultimately the court said you frame a scheme. While I was working in Panchayat, and the division bench recorded that no scheme was framed. So I am entitled for the benefit of the scheme which has been framed by the administration. Now, my lord, page 118, last second paragraph, the court said, you consider his case in terms of the scheme framed by you by taking into consideration Uma Devi case. So the scheme which they have formed by framing that scheme, they have given relaxation to 176 persons. I am at par with them.
Relaxation with regard to the sanction posts also.
No, relaxation. They have given relaxation. My lord, Uma Devi says,
Relaxation.
relaxation will be education qualification.
Well,
Uma Devi said.
even they have relaxed.
They have relaxed. Now the question of sanction post doesn't arise because I was working in the the Panchayat, at no point of time in any litigation, they have taken this stand that I am not working against a sanction post. Because this is the third round of litigation. I can show to my lords their AO at page 73. At the first round of litigation. Kindly come to page number 73. What is their stand, my lord? The stand cannot be changed, my lord. I am armed with those judgment or those line of judgment, my lord. Page 73, my lord. This is a opposition filed in the writ petition 293. Now, my lord, page 75. Kindly come to page 75. First paragraph, last 4 lines. They say that the petitioner was engaged on muster roll under PBMC and posted under the administrative branch. Page number 76, they say, my lord, second paragraph. It is submitted that, page 76. It is submitted that in pursuance of the decision taken in the meeting held under the chairmanship of Chairman PBMC, in presence of Deputy Director, Panchayat Secretary, Directorate of Panchayat and Office PBMC, and also the decision taken by the council meeting held on so and so, the petitioner was engaged on muster roll under PBMC and posted under the administrative branch. Now, my lord, it is not by an administrative order. The autonomous body, my lord knows very well, the autonomous body are governed by the regulation, and under the regulation, this Panchayat regulation and all, my lord, the resolution is the ultimate which has been taken by the authorities. On the basis of this resolution, they were taken, their service has been taken from Panchayat to municipality. Now, my lord, can you see their stand, the stand which has been taken at page 84? This was the stand all along taken by them at paragraph number 2, subpara 2, my lord, page 84. There are total 1,190 numbers of casual mazdoor, 11 DRMs and 40 numbers of muster roll are working under PBMC with the petitioner. If the petitioner is allowed, floodgate will open for all of them, which is against the spirit of the existing recruitment rule. Further, the financial implication for regularization of 200 number of casual mazdoor would be around 1.35 crore per annum. Since octroi had subsumed with GST, hence the PBMC has been facing acute financial crisis and completely depends on Andaman Nicobar administration for financial assistance. The prayer of the petitioner is outset to the provisions of the recruitment rule by relaxing the eligibility criteria. Hence, the prayer of the petitioner cannot be acceded to and his claim is rejected accordingly. So, my lord, this was their stand all along. When they filed the appeal, my lord will find the grounds taken in the appeal at 101. Grounds are at 102 and 103, my lord. My lord will find there is no such ground. Ground number 4, once again, that 1,190 people. And my lord, kindly see the next page, my lord. No such ground was taken. Now, at the last round, at the third round of litigation, when the court directed them to act strictly in terms of the scheme promulgated by them, by taking into consideration Uma Devi, go, my lord, pass this order. Now, my lord, 118, one more paragraph is there. The court says if he is suitably, then order has to be passed as at par with the one said 176. Now, my lord, kindly see. My lord, I am just placing some portion of the division bench judgment. My lord, division bench given a consider everything, my lord, and there are several findings which is in my favor. If my lord kindly come to page 109. Kindly come to my lord 111, my lord, 111. It says, my lord, however, second paragraph, however, the petitioner respondent continue to agitate his grievances for regularization as he has rendered more than 10 years of service, uninterrupted service. It is not in dispute that in terms of the judgment of Uma Devi, a one-time measure was taken by the Port Blair Municipal Council regularizing the service of 176 daily rated mazdoor by giving relaxation, the age and the educational qualification. Thereafter, my lord, the next paragraph is the stand taken by them. If my lord will find 1190 casual worker, last fourth line from the bottom. Thereafter, by the impugned order, the learned single judge held that the respondent cannot be put into disadvantaged position with 176 working under the PBMC had been befitted by such scheme as would offend Article 14 of the Constitution. Now, my lord, kindly come to 113, page number 113. Second paragraph. On the conspectus of the above submission, it is undisputed that the petitioner respondent was engaged on 1st November 1995 and worked in the said Panchayat continuously. Though the service was terminated, but the order of termination was set aside by the Labour Code with the categoric observation that the period of termination shall be counted as the period of employment for the purpose of continuity of service. And therefore, there is no difficulty in construing such order that the petitioner respondent continued in service uninterrupted and without any interim order of the court. My lord, despite of this categoric finding of the court, while rejecting my candidature for regularization, they arrived to the finding saying that under the dint of an interim order, I was continuing in the employment. There is a category, this itself speaks the malafide attitude of the authority, my lord. Thereafter, my lord, next paragraph. Subsequently, the said Panchayat was included in the municipal council area as a decision was taken by the administration to extend the territorial limit of the municipal council, and it would appear from the record that the petitioner respondent was taken in the muster roll of the municipal council and still rendering his service in such status. Several writ petitions were taken out where the writ petitioners were disposed of with the categorical finding that if any scheme, I am harping upon this, my lord, if any scheme is framed in terms of the mandate given in Uma Devi, the candidate of the petitioner respondent should be considered for the purpose of regularization. Even one of such proceedings, the division bench of this court directed the Panchayati Raj administration to frame a scheme in terms of the mandate of Uma Devi, yet there is no attempt shown on the part of the administration to comply the direction. Now, my lord, kindly come to page 116, my lord. Then thereafter, ML Kesri and all taken into account, my lord. Now, kindly come to 116. The court says, my lord, got it, my lord? The court said in a recent judgment rendered in the case of Santlal and others, the Honorable Apex Court held the judgment in Uma Devi should not be construed to preclude the claim of the employer seeking regularization after that exercise have been undertaken with respect to some employees. It is further held that the deprivation of some of the employees would result in complete foreclosure of right, whereas the said one-time measure is a continuous exercise in these words. The judgment of this court in Uma Devi does not preclude the claim of employee who seek regularization after the exercise has been undertaken with respect. Now, my lord, kindly come to next paragraph, my lord. The law propounded in the above notes decision leaves no ambiguity that one-time measure should not be construed so narrowly or strictly to deny the rightful claim of the daily rated mazdoor. If some of the employees has been considered, leaving the others, the said one-time measure must be construed as a continuous process and the candidature of those employees can be considered. There is a peculiar fact involved in the instant case. Admittedly, the petitioner respondent was employed as daily rated mazdoor in the said Panchayat. The Panchayati Raj Institute never floated any scheme as one-time measure in terms of the mandate of Uma Devi, despite the direction passed by this court in the mandamus appeal. The fact of the petitioner respondent was kept in lurch in absence of the one-time measure to be undertaken by the Panchayati Raj Institute and subsequently put to the disadvantaged position after the merger of the Panchayat within the municipal council areas. By a conscious decision taken by the Port Blair Municipal Council, all the daily rated employed by the concerned Panchayat was included in the muster roll of the Municipal Council and treated to have been employed under them. The fate of the petitioner respondent remained uncertain for the reason that the Panchayati Raj Institute never framed the scheme as one-time measure to regularize the service of the daily rated mazdoor, and subsequently such right is foreclosed as they have been taken in such status by the Municipal Council. By such executive fear, the right cannot be destroyed, and in view of the decision of Santlal, scheme framed by the Municipal Council cannot be said to have been concluded or exhausted, but must to be read as continuing process. The rightful claim of the employee cannot be dismissed when they are not at fault, more particularly when the said Panchayat was included with the municipal council limit. And thereafter this finding is there, my lord. So, my lord, the division bench has considered everything. Now, today they are taking one stand, tomorrow they will take one stand. That is not permissible under the law. Now, my lord, kindly see the order, how the order was passed. Page 122. First, they have considered all the factual aspect. Page 124, my lord, kindly come. Now, first time, my lord, I am before the court of law from more than 4-5 years, 4-5 years after the municipal has. Now, my lord, first time in this order at page 124, second paragraph. And whereas in the present case, the petitioner was not appointed in duly sanctioned post. Page 124, my lord. At this junction, they cannot say they have accepted my employment. It was up to the municipal, when, my lord, I have been reinstated in service by a competent court of law, where my lord will find in the judgment, it was further recorded. If any vacancy arises, I shall be considered. That is there in the said order of the labor court. Now, my lord, it says, and whereas in the present case, the petitioner was not appointed in duly sanctioned post, apart from not having been appointed against a sanctioned post, he was also appointed through the order of the labor court, while dated so and so after being removed from service. Thus, the condition set in Uma Devi case that the employee should have been working for 10 years or more without the cover of the order of court or of tribunal is also not fulfilled. This is absolutely wrong, contrary to the judgment of the division bench. Thereafter, my lord, if my lord comes to last paragraph, it says, now therefore, considering all facts and taking into consideration the matter that the petitioner is not eligible as per the recruitment rule. Pausing for a minute, my lord. There is no question of recruitment rule. You have given relaxation to 176%, and without considering that, how I am not at par with them, they say that it is not eligible as per the recruitment rule. How they can say so, my lord? The court has said you consider his case at par with 176. Now, my lord, what is the wrong in the order of the tribunal, the writ court, my lord? Kindly have the order, my lord, at page 154. And before that, my lord, I will just show the operative portion of the judgment of the tribunal, my lord. My lord, kindly once come to page 60. The operative portion of the award. That the action of Director of Panchayat, Andaman Nicobar Administration in disengaging or terminating so and so in lieu of monthly salary from the service is neither legal nor justified, and the first party workman is the first party A. Subramaniam, subject to his opportunity against regular vacancy, is hereby entitled to be reinstated into service of Chowkidar under the Panchayat on usual scale of salaries, subject to further benefit of emolument as a fixed time by the administration with immediate effect of so and so from time to time by the immediately effect. However, by making it clear that the period of disengagement be taken notionally as period of employment for continuity in service, however, without any back wages. So, my lord, here in that award, there was a rider that if in future any vacancy is arrived, then he must get an opportunity against regular vacancy. That was an order of the tribunal. The Directorate of Panchayat contested the case. They did not challenge. Now that is binding upon the administration. Now, my lord, kindly come to page 154. Only by passing that order, my lord, stand was changed. Now, my lord, kindly see the judgment, my lord, 154. By the impugned order, the petitioner claim for regularization of his service was rejected on twofold. My learned friend has read, my lord. The matter has a checkered history. The petitioner was employed as peon cum chowkidar in Garacharma 2, Garacharma Panchayat since October 1995. His service was terminated summarily by the Gram Panchayat. He approached the labor court under the provision of...
Do not read the whole judgment.
My lord. My lord, page 156. Last paragraph. The court said what stand or before this court is that the PPMC has not been able to demonstrate before this court that the post of peon cum chowkidar was not there in the Gram Panchayat, Garacharma Gram Panchayat, or that it is not a sanctioned post. My lord, at this junction, when it was transferred, they cannot take this stand that there is no sanctioned post. The court is also noticed no answer in terms of that the labor code has in its award dated so and so clearly held that the termination of the petitioner, even as a temporary employee, is illegal. Therefore, a presumption that the post of so and so is a sanctioned post. The labor code found that the petitioner was a workman under the Panchayat. Now, my lord, the court has considered everything and arrived to a finding. My lord, the order is absolutely wrong order, my lord. My client is going to be retired in another 6 months, my lord. From last several years, he is before the court seeking the benefit of Uma Devi. So, my lord, at the cost of reputation, I am submitting, my lord, my case is of parity. And when a scheme was framed, the court said the scheme is a continuous scheme. And since the Panchayat has not framed a scheme, therefore, I am entitled to be covered by the said scheme. And my lord,
then admittedly a scheme was framed.
yes, that is 176 persons were admittedly a scheme was framed by the PBMC.
PBMC.
The court said that is an ongoing scheme. You consider his case in terms of the said scheme. Panchayat has not framed any scheme. That's why the court has recorded, my lord. I am lingering on. Since if they could have framed a scheme, I could have been observed over there. But now the court said they have taken a stand that it is only one-time scheme. The court, after referring those judgment, the court said no, it is an ongoing scheme. Unless, my lord, the Sant Lal, it was said, unless the last person in the said category is observed, the scheme is an ongoing scheme. And now, my lord, the judgments which my learned friend has relied upon, that has got nothing to do. Because here a scheme was promulgated in terms of the judgment of Uma Devi by giving relaxation. So I am at par with them. I am seeking that relaxation.
Right.
And my lord, the grounds, my lord, the subsequent change in the grounds is not permissible under the law. If, my lord, please, I have 3 judgments, I can rely those judgments, my lord. That stand cannot be changed. One is state of West Bengal versus West Bengal. So, my lord, the judgments are there. 2000, my lord, I don't have the judgment. I have the reference, my lord. 3 judgments are there. 2010, volume 1. L&S 315, my lord. State of West Bengal versus West Bengal registration. Copyright.
315.
315, my lord. L&S.
LNS, yes.
State of West Bengal versus West Bengal Registration Copyright Association. Paragraph number 73 and 76, my lord.
Copyright Association 73 and 76.
6, my lord. There are other 2 judgments, if my lord
Yes.
allow me. Page that is 2010, volume 3. SCC 637.
Yes.
Krishna Singh versus Executive Engineer, Haryana State Agriculture Marketing Board, my lord. It's a short judgment, my lord. Para, I am not.
Executive Engineer, Haryana.
Haryana State Agriculture Marketing Board.
All right.
And last one is, my lord, 2011, volume 2, SCC 316.
Yes.
State Bank of India versus Vidyut Kumar Mitra, BIDYUT.
Spelling?
BIDYUT,
Vidyut Kumar Mitra.
my lord. These judgments were, my lord, I referred in one of the cases, and this court, considering this, did not allow their application, and the mandamus appeal was dismissed, my lord.
And rejoinder on the two short sentences.
Yes.
First is, my lord, so far as the division bench's order is concerned, my lord may only have page 150. The division bench of Justice Harish Tandon was that order, my lord, which my learned senior has read, except I have also read portions of it, but my lord, page 115. The division bench itself said, from the aforesaid observation, it appears that an exception is carved out where appointment is irregular against duly sanctioned, and the employers work for more than 10 years without intervention. The question of regularization has to be considered. The apex court further directs, of course, from the framing of the scheme, and then 115 bottom ML case we set out where these conditions again that there has to be regularly appointment and again sanction post is reiterated. And 118, my lords, by this one paragraph, my lords, in my humble submission, 118 second paragraph. However, we are not concurring with the view of the single judge in directing regularization of service without the other conditions as considered in Umadevi. So, my lords, these are conditions under law. So, my lords, there cannot be estoppel against law, my lords. And secondly, my lords, so far as the status of this writ petition is concerned, page 145, the Panchayat authority itself has held that he is not against a sanction post, and subsequently that order has been upheld at page 149 by a learned single judge. And lastly, my lords, at it is no so far as the scheme that has been framed, admittedly, and my learned senior also has fairly in the course of submissions accepted this, that those 175 people were against sanction posts. So there is no dispute on the fact that they are not equals, because they were against sanction post. The free scheme was framed for people who were against sanction post. This gentleman is not against a sanction post in PBMC, admittedly, and there is, so far as his employment against the Panchayat is concerned, also in my humble submission, page 145 has been upheld at page 149. And the labor court order is was only on the issue of re-engagement after his termination. So that doesn't make him a appointment against a sanction post.
My lord, only one thing, all the judgments which were passed in the case of this petitioner, right from 2013, were taken note by the division bench. All the judgments, and thereafter the finding was arrived. And there is no discussion with regard to sanction post.
Very well. Hearing concluded, judgment reserved. No further division bench matters will be taken up. That is at 3 o'clock.
3 o'clock.
Yes, yes. That we have
I
fixed at
thought
3
we
o'clock.
should after the division, which after my lords.
No, 3 o'clock, we will sit in the single bench, thereafter again division bench. We'll take up that matter.
Any mentioning not in the list? Any mentioning in the list? Item number one. WPA 849 of 2023.
Why I am seeking extension of time to bring the gazette notification. I could not find out one since it is back in the year 1978.
But I am for the petitioner, the interim order are granted. That may
It
be.
will be extended, nothing doing.
Why not?
On the prayer of the learned advocate. Representing the respondent numbers 1 to 3. Time to produce the gazette notification. Stands extended. Stop. The interim order subsisting in the matter is extended till 24th November 2023 or until further order, whichever is earlier. Liberty to mention.
Obliged, Lordship.
Item number two.
Item number 2, I am for the petitioner.
23.
I know this matter may be short password. Mrs. Anjali Nam is appearing for the private respondent.
On 18th August, your lordship directed the concerned engineer to go to spot and inspect, file a report after giving the copy to me. Nothing was done.
No, report has been filed, my
No,
lord.
no, report.
No inspection was conducted.
Inspection, no, no, it was done, my lord, you filed.
How they conducted inspection?
No,
I
no,
fail to understand.
yes, yes, my lord, I will explain, my lord. What has happened is, my lord, it's a mistake. I should have said it at the very outset.
1 minute.
My lord, what happened is, my lords, actually, my lords, we had communicated the order orally, my lords. On that basis, they took steps. They, my lords, by the time the order came, my lords, that there was requirement to give notice, my lords have said to all parties, I think.
Yes, yes.
To all parties or all, no, in this case, all necessary parties.
Yes.
So what happened is, my lords, that notice was not given to them, my lords. I think, my lords, I should fairly say, my lords, we'll
My
do it
lord.
again in that case.
I have
They will
given,
do it again.
my lord, kindly see this.
They will do it
I will
again.
do it again. I have given notice. The order was communicated
So
by.
that I,
Very well, they will.
we'll do it
Seen,
again.
my lord.
No, we'll do it again, my lords. I am making a.
He is going, making construction, my lord.
What is the?
No, report is that there is no new construction.
Construction.
The already demolition order is there, let.
No, no, that is the old construction is there. There is no new construction.
Construction, my lord. No new construction is there. No new construction is
No,
there.
we'll carry out this.
This will happen.
Very well, very well.
We'll come.
I'll clarify it. Please
My
come.
lord, this is amounting to contempt.
No, no, order is not yet there, my lords. I'm
No,
sorry.
order is communicated by me, my lord. Kindly see the communication.
My lord, this matter may be short password because there is
Why
many
possible?
many materials are there already. Appeal is also pending.
Municipal council is sleeping.
My lord, already appeal is pending here.
By order dated 18th August 2023,
My lords, I'm apologizing, my lords. It can be recorded that I have apologized.
the court directed the concerned engineer of the municipal council to cause a spot inspection upon prior notice to all the necessary parties to ascertain the nature and extent of unauthorized construction, if any, and to file a report before this court. Stop. Next. The order passed by the court was communicated to the Secretary, Port Blair Municipal Council by a communicating letter of the learned advocate for the petitioner on 21st August 2023. Stop. Where is your report? Please give a copy.
This is filed by affidavit is there.
Okay.
That was not supplied to me. Now you supply.
Learned advocate representing the petitioner submits that no inspection was conducted in terms of the direction passed by the court. Stop. Paragraph. Learned advocate representing the municipal council submits that an inspection was conducted. However, the notice of spot inspection could not be served upon the necessary parties. Stop. Learned advocate submits that the council may be permitted to re-inspect the construction. Stop. Next. Learned advocate representing the private respondent submits upon instruction that no new construction is going on at present. Stop, next paragraph. According to the petitioner, comma, petitioners, the private respondents are continuing with the construction work. Stop, next. According to paragraph, according to the provisions of law, construction can be made only in accordance with the direction passed by the concerned authority and not contrary to the same. Stop, next. Here the petitioners allege illegal and unauthorized construction at the instance of the private respondents. Stop. The council is yet to come to a decision as to whether there has been any illegal construction or not. Stop, next. Though it has been submitted by the learned advocate representing the petitioners that an order of demolition was passed by the council as there was unauthorized construction made at the instance of the private respondents. Where is the order of demolition? Please show.
Page 17.
17.
Duplex house was constructed.
Very well. But on a perusal of record, it appears that the said order of demolition was passed way back in 2015. Stop, next. Accordingly, the concerned engineer of the municipal council is directed to take strict steps. Steps strictly in accordance with the direction passed in the order dated 18th August 2023. Stop. Prior notice of spot inspection shall be given to all the necessary parties. Stop. A report shall be filed before this court on the adjourned date. Stop. The municipal council shall ensure that construction that no unauthorized construction is carried on at the instance of the private respondents as alleged or at all.
Let there be
My
stay
lord,
order,
one
my lord.
submission.
Let
My
Let
lord,
there be a stay order.
it cannot be, my lord, one submission, the report submitted by
let the matter.
other side, Mr. B may be seen, my lord.
Again.
There is no construction is going on, they have reported.
Let there be a stay order.
They have mentioned.
Let there be a stay order, my lord.
18th September 2023.
My lord,
My lord,
my lord, I
it-
prayed for
my
stay
lord,
of
then
further
the hearing may be
construction. That
taken
order may be passed.
my lord, then the hearing may be taken up.
I specifically prayed, my lord, in my prayer B, during pendency of.
This
the
is
application.
what the court has directed. No unauthorized construction, the
My lord,
municipal council will.
construction is going on, municipal council is hand in glove.
My lord, annexure B may be seen, my lord, filed by the municipal, my lord. Going on.
Otherwise, he will complete the construction, illegal construction.
Item number.
Oblige, my
Will
lord.
take photographs and annex it with the.
My lord, that will be recorded, my lord.
Very well. Very well. Liberty granted to the petitioner to produce photographs in support of the submission that illegal construction is going on at the behest of the private
My lord,
respondents.
yes.
Oblige.
Oblige.
I don't have.
Item number 3, WPA 886 of 2023.
I'm appearing for the respondent authorities in this matter, my lord.
My lord, this can be disposed of, my lord. Under the regulations prevalent in the islands, the subdivisional officer is the competent person to grant permission for diversion of land from agricultural to house site or house site to commercial. I make an application, my lord, before the subdivisional officer during the year 2018. Now, 5 years have elapsed.
They have not
They had
considered.
not considered. In between, what they had done, my lord, they had formed a committee which is called as land usage committee. Now they had categorized that within 500 meters, square meters, the subdivisional officer would do, and an area beyond that would be determined by the land usage committee. Now the matter came up for consideration, my lord, before the honorable court, my lord, wherein this amendment to the rules was challenged. Now the honorable high court, by an order which is of enclosed, has struck down the amendment to the rules
saying that the constitution of the land usage committee is contrary to the provisions of the regulation and it is only the SDU who is competent to do so. So I would only pray, my lord, let there be a direction that the SDU should take an decision on my applications, my lord.
Which page is your application?
My lord, it is at page 24 and 25. 24, page 24, my lord, I had submitted in 2018 and in 2023, I had given a reminder subsequent application yet again. It's 5 years and there no decision is being taken.
I request, my lord, the copy, because there are two writ petition, only one copy has been.
Yeah.
Second, the next writ petition copy is there, but this copy, WP copy is not there.
So I'll give you one more.
Why two writ petitions?
But the other is subject matter is different, my lord.
Other is not maintainable.
Oh, very well. This one is maintainable?
No, my lord.
Consideration? This one?
No, my lord, since it is, yesterday only it has been served.
It
And
was served on
No, the petition is praying for a direction for consideration. That can be passed.
17.
Direction for consideration of the application of the petitioner seeking
My lord,
permission for diversion. That can be.
My
This is
You
how
can
the
start.
authority is
Yes, ma'am.
performed. You have served them on 17, they have not even supplied the copy to their learned advocate. And have not taken the decision for 5
Please
years.
take down the application filed by the petitioner.
it's,
Petitioners, madam, two, brothers.
Seeking permission for diversion of their land is pending consideration at the end of the subdivisional officer since June 2018. Stop. A reminder was filed in August 2023. Stop. None has been considered till date. Stop. Paragraph. The learned advocate representing the petitioners rely upon the judgment passed by a coordinate bench of this court on 11th January 2023 in WPA 43/2019
A bunch of.
in the matter of Smart Space Infrastructure Private Limited and others versus Union of India and others, wherein the court was of the opinion that the subdivisional officer is the competent authority to decide the issue in question. Stop. Next. I have heard the submissions made on behalf of both the parties. Stop. As it appears that the application filed by the petitioners is pending consideration for a considerable period of time. Accordingly, no useful purpose will be served by keeping the writ petition pending. Stop. Paragraph. The writ petition is accordingly disposed of by directing the subdivisional officer, South Andaman District, being the respondent number 2 herein, to take into consideration and dispose of the application filed by the petitioners in accordance with law at the earliest, but positively within a period of 4 weeks from the date of communication of this order. A reasoned order shall be passed and communicated to the parties immediately thereafter. Stop. Prior to passing a final order in the matter, comma, a reasonable opportunity of hearing shall be given to the petitioners. Stop. Paragraph. It is made clear that this court has not entered into the merits of the claim of the petitioners, and all points are left open to be decided by the aforesaid respondent at the time of consideration of the application made by the petitioners. Stop. Paragraph. Learned advocate for the petitioners is directed to forward a copy of the application received by the respondent authority on 21st August 2018 and the reminder thereto dated 9th August 2023 to the aforesaid respondent at the time of communicating the order of the court. Writ petition stands disposed.
Like,
I pray, my lord, instead of 4 weeks, may it be extended to 8 weeks.
8 weeks.
8 weeks.
Pending for 5 years.
Yes, 4 weeks is very. It will-
Short time.
short
Make
time.
it 8 weeks.
Much obliged, Lord, sir.
Item number 4, WPA 887 of 20.
My friend was raising something.
Yes, this is an order passed by SDO.
Is this an appellate authority?
Appellate authority is deputy commissioner under section 28 of the Land Revenue and Land Reform Acts. As such, this application is not maintainable.
Very well. What will be your
My
submission?
lord, the application
give-
my lord, has come basically on the count of jurisdiction. If it's on the count of jurisdiction,
SDO doesn't have the jurisdiction,
no, it doesn't have the jurisdiction.
but then you can raise this issue before the appellate authority also.
There is no power, my lord. There is always a petition is maintainable if an order is passed without jurisdiction, my lord. Their officers will decide the application and we know the fate of the order, what would be there. Their interpretation of the provisions of law, my lord.
What is the issue?
My lord, the issue is the petitioners before my lord, he's recorded owner of certain portions of land. It's an agricultural land. The allegation is that he had raised a certain construction on these particular plots of land without converting the same into house site, my lord.
But then the earlier writ petition, you seek for a permission for conversion.
My lord.
It's the same plot of land.
Connected.
If that is allowed,
My lord,
then this will automatically go,
Yes,
my lord.
isn't it?
yes.
I'll just place it, my lord, because there is a question where I can rectify the defects which have occurred, my lord. At the present moment, I'm not going to the minutes of the case or as to how I would rectify my defects or the omissions committed by me. The only limited question is number one, my lord, his officers had come to my premises and he has sealed the premises, number one. There are two provisions under the law. Number one, that yes, there is a provision that if it is used for any other purpose, then there will be an extinguishment. But what are the repercussions? I'm not going into it. Now, the only question is whether there has been a conferment of power upon the subdivisional officer by the lieutenant governor to exercise the powers. My lords may kindly come to the regulation, because where the
No, but then you say that the SDO has the power to consider the application for
that's a
diversion.
different chapter.
Now, what
This
is the extra thing that the SDO has done?
SDO has sealed the premises, my lord.
That he cannot do.
That he cannot do. My lord would see regulation. Page 4. I think it should be the same pagination, my lord, in the regulation.
Yes.
Regulation 11, my lord.
Hmm.
The chief commissioner may by notification confer on any person the power conferred by or under the regulation on any revenue officer. The subdivisional officer is the revenue officer. There is no dispute, no quarrel about it, my lord. There are certain provisions under the regulation where the powers are specifically indicated who would exercise the powers. But where the provisions are silent as to who would exercise the powers, then in such event, then section 11, regulation 11 would come into play. The lieutenant governor, chief commissioner now is the lieutenant governor, has to issue a notification confirming the power on a particular officer to exercise those powers. Now, let my learned friend show that the powers so indicated under regulation 162 has been conferred upon the subdivisional officer. If my learned friend can produce the notification tomorrow, the matter would end there.
I will use my opposition, my lord. Regulation 40.
Under which regulation has the order been passed?
My lord, it's been passed under regulation 162, which possibly should be at page 33. Or
Yes, 162, I see the extinguishment of
the
tenancies.
interest of a tenant in his holding or any part thereof shall be extinguished.
But then who is the
Six.
appropriate authority?
No, for where the regulations are silent, there is no specific conferment of the power,
Very
then
well.
regulation 11 would come into play.
You show me the provision which permits the SDO to take a decision
On
with regard to the conversion or diversion.
is this one,
40.
40,
40.
40, my lord.
46 first.
That's totally a different chapter, my lord. Sub-regulation 2.
Yes.
No land assessed for use for one purpose shall be diverted to any purpose without the previous permission of the subdivisional officer. So here there's a specific conferment for the purpose of converting the land, SDO is the competent authority. Not to extinguish or to seal the premises, whether there is no powers have been indicated on section 162. So the regulation is silent as no officers or revenue officer has been indicated as to who would exercise the power, then it is open for the lieutenant governor to confer that power upon a particular revenue officer to exercise those powers. If those powers are not there, then this order passed by and the action undertaken by the SU is without jurisdiction.
Where is the impugned order?
Page 36, my lord.
Illegal diversion.
Relevant is page 37. He says that he's exercising powers under section 162, last para. Page 36, relevant is page 37, last para.
(151). What is 151?
151 is executing an order passed under 162, my lord. And that is that is also quite interesting, my lord. 151, possibly, my lord, it should be at page 28.
Yes.
A tenant shall be liable to be ejected. It's executing an order passed under section 162. Shall be ejected from his holding by an order of the subdivision officer made on the following grounds, namely so and so. And if my lord will kindly come to subclause 3.
Yes.
Subregulation 3. No order of ejectment shall be executed before 1st day of February or after 30th day of April in a year. I don't know the reasons why these dates are there, but execution can't take place within these dates. Now he is executed, he has passed an order and executed within the dates which is prohibited under subregulation 3 of regulation 151.
After the 30th day of April. Before the 1st day of February. So from April to February.
There's an automatic ban. It's their regulation. They'll have to follow it. It takes 150.3.
With regard to the jurisdiction, I'm not very satisfied. But then since he wants to file an opposition, let him file.
Let there be a stay of this order, my lord.
No stay is warranted.
Why no stay is warranted?
Section 28, my lord, may see, my lord. Subclause A.
No, I don't dispute the fact that there is an appeal. There's a provision for appeal.
If such order is passed by a revenue officer.
SDO has to demonstrate that he has the
B.
powers to exercise.
Any order is appealable to the deputy commissioner passed by subdivision officer.
Any order would not include an order without
Yes.
jurisdiction.
He can very well assail that point before the appellate authority.
Please take down. The order passed by the subdivisional officer South Andaman. Dated 4th August 2023. Exercising power under section 162 within bracket C, A and N, I, LR and LRR, 1966 is impugned in the instant writ petition. Stop paragraph. Specific case of the petitioner is that the subdivisional officer does not have the jurisdiction to pass order under the aforesaid provision. Stop.
In view
Next.
of regulation 11.
The petitioners rely upon regulation 11 of the aforesaid rules. Stop. It has been submitted that the chief commissioner is yet to publish any notification conferring the power to act upon the subdivisional officer. Stop. Next. It has further been submitted that the order dated 4th August 2023 ought not to be executed
Between 1st February and 30th of April.
in view of the bar mentioned in regulation 1
Subregulation 3 of regulation 115.
151 within bracket 3 of the aforesaid regulations. Stop. No order of ejectment shall be executed before the first day of February or after the 30th day of April in any year. Stop. Next. Paragraph. Learned advocate representing the respondents oppose the submission made on behalf of the petitioners. Stop. It has been submitted that the impugned order is an appealable one. Stop. The petitioners ought to have preferred an appeal without approaching the writ court. Stop. Paragraph. In response to the aforesaid submission, learned advocate for the petitioners contend that an order passed by any authority without the jurisdiction to do so is a nullity in the eye of law, and the same will not act as a bar to prefer writ petition under Article 226 of the Constitution of India. Stop. Next. It has been submitted that the order ought not to be executed within the period as mentioned in the regulations. Stop. Next. Paragraph. The respondent authorities are directed to file their affidavit in opposition in response to the argument forwarded by the petitioners. Stop. In the meantime, the subdivisional officer, not in the meantime, the subdivisional officer, South Andaman, is restrained from acting or taking any steps further to the impugned order dated 4th August 2023 in view of the restriction imposed in in regulation 151 within bracket 3 till 30th September 2023 or until further order, whichever is earlier. Stop. Let affidavit in opposition be filed within a fortnight.
My lord.
Reply, if any, within a week thereafter.
Obliged.
List in the next circuit.
Obliged, my lord.
Number 5. Your Lordship, I have that case, Your Lordship, without issuing any notice, any kind of information, suddenly, Your Lordship, the Tehsildar with Bari came to the spot and started demolition.
I pay for the respondent authorities, my lord. Since yesterday night only I received the copy, my lord.
What is
We
there?
need to, the copy of the writ petition only I have received. The property is situated at Havelock. So we need time to file, take a
But
report.
then did you take instruction as to whether the demolition is going on upon giving notice or not? This take this much instruction, and what does your instruction say? Any instruction given?
Only report is there, but.
And what does the report say?
Report is that they have started constructing house and shop. in
Very well,
the-
they have
And
started
in-
construction.
Yes.
You take steps after giving notice. Who stops you?
That further report I require time. Since it is a new matter, my lord, I have to take.
They have already demolished, Your Lordship. So let them file the opposition, they
Yes.
will be continuing. So that, Your Lordship, I can take appropriate steps.
Learned advocate representing the Tehsildar South Andaman
Both, Your
submits.
DC and this.
Both the respondents. So they are paying for both the respondents.
Very well, on behalf of the respondents. Seeks time to file opposition in the matter. Stop. Learned advocate is yet to receive instruction as to whether the demolition work has been conducted upon giving prior notice or opportunity of hearing to the petitioners. Stop. Next. On such prayer, comma, let affidavit in opposition be filed within a fortnight from date. Reply, if any, by a week thereafter. list the matter in the next circuit. Stop. The interim order passed on 21st August 2023, restraining the respondents from carrying on any further demolition work is extended till 29th, till 30th of September 2023 or until further order, whichever is earlier.
Obliged, Lordship.
Item number 6.
Your Lordship, I have got it.
It's also same, my lord.
But here, your Lordship, the demolition has not started.
Yes.
But they.
Interim order is there.
Intention shows, your Lordship.
Interim order is there.
There,
Yes, so it may be extended, let them file a petition.
my lord.
Very well, same order can be passed. And the date of the order is,
No,
it
your
was
Lordship,
passed on 21st of August.
there the demolition, they have said that demolition is there. With or without notice, that is the thing which is required to be looked into. Here
Yes.
demolition has not taken place. So otherwise they will take advantage of this and again demolish the
Very-
structure.
Very well. Learned advocate representing the respondents is yet to receive instruction in the matter. Stop. Prayer has been made for allowing time for filing opposition. Stop. On such prayer, let affidavit in opposition be filed within 2 weeks, reply if any, by a week thereafter. Stop. The respondents are restrained from carrying on any demolition work till 30th September 2023 or until further order, whichever is earlier. List in the next circuit.
Obliged.
Obliged, Lordship.
Item number 7.
My lord, I am for
WPA 897 of present city.
Innocuous prayer, my lord.
I am for the respondent authorities. my lord.
Page number 9 is my record of rights, my lord. Page number 9 is my record of rights. Page number 10 may be seen, my lord. Map is there. My land is landlocked land. There is no access,
401,
my lord.
yes, 401, no access.
11. My lord, on page number 11 may be seen, my lord, I filed an application before the deputy commissioner to set apart the land. That is kept pending, my lord, since 18th April 2023. My innocuous prayer is direction upon the deputy commissioner to
Please
decide.
come. The application filed by the petitioner under section 198 of the A&N ILR and LRR regulations 1966 is pending consideration at the end of the deputy commissioner since April 2023. Stop. Without going into the merit of the claim of the petitioner, comma, the instant writ petition is disposed of by directing the deputy commissioner, comma, South Andaman district to take steps to consider and dispose of the application filed by the petitioner in accordance with the prevailing regulations at the earliest, but positively within a period of
8 weeks, my lord.
4 weeks is sufficient, my lord. Small matter, why 8 weeks?
Set apart.
Small.
8 weeks. 8 weeks at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. An opportunity of hearing shall be given to the petitioner prior to passing a final order in the matter. Stop. Reasoned order shall be passed and communicated to the petitioner immediately thereafter. The learned advocate for the petitioner is directed to forward a copy of the application dated
18th April.
18th April 2023, along with the copy of the record of rights and the map to the aforesaid respondent at the time of communicating the order of the court. Writ petition disposed.
I am deeply obliged, my lord.
Obliged, Lordship.
Item number 8.
Group PA 899 of 2023. Your Lordship, I am for the petitioner. I am the recorded tenant of a land, Your Lordship, and I have the private respondent, Your Lordship. He has started carrying out service. Service is there, Your Lordship. I filed the affidavit of service. The problem is that, Your Lordship, I have submitted application before the Tehsildar so that the illegal construction which he is carrying out in the setback area which falls between the footpath and my land. That is.
Where is the track report? There is no track report.
Your Lordship, nowadays, Your Lordship, they are not
Not
uploading the track report. Your
Not
Lordship.
uploading.
Yes, they are not uploading.
What is your prayer?
Very difficult.
What is your prayer?
My prayer is that, Your Lordship, the Tehsildar may be directed to dispose of my representation until such time the Tehsildar should ensure that no construction is carried out on the government land. I am specifically mentioning government land.
Which is the government land?
Your Lordship, it falls between my land and the footpath. I have specifically described. Kindly see,
What
Your Lordship,
type of construction is being made?
structure. He has started constructing a structure, a shop.
Shop.
Because it is near to the road. So he found some land between the footpath and
And
my
is it a
land.
temporary shop, a shed type of thing?
No,
Or
Your Lordship.
permanent construction?
No, he has raised pillars, Your Lordship.
Concrete pillars?
No, with
Brick.
iron pillars there. He has.
Iron pillars?
Yes. And he has covered the, means with the pillar, he has connected all the sides.
With bricks?
Not bricks. The pillars have been connected. By that time, we have stopped it.
All right.
And made a representation to the Tehsildar. So further construction should not be there, otherwise it will take hardly.
And
50
that
days.
portion is the government road.
Government land. I have
Government
specifically
land.
mentioned. I'm not
Raise your,
mentioning
raise your application.
Your Lordship. Your Lordship, page number 16.
Please come.
And kindly see my prayer, Your Lordship. Prayer in the writ petition. I specifically mentioned government land. So government land can't be
The
of any other
petitioner,
person.
the petitioner alleges that the private respondent is guilty of raising unauthorized construction over government land. Stop. A representation was filed before the Tehsildar South Andaman on 11th August 2023. Stop. The same is pending consideration till date. Stop. Paragraph. It has been submitted that the private respondent, that the petitioner has somehow managed to restrict the private respondent from carrying on the construction work at present, but the construction work may resume anytime. Stop. Next. Prayer has been made for consideration of the objection that is pending consideration before the Tehsildar. Stop. Next. There is no proof of service of the writ petition upon the private respondent. Stop. The writ petition was posted on 21st of August 2023. Paragraph. In view of the order that I propose to pass, the private respondent will not be prejudiced in any manner whatsoever if the writ petition is disposed of in the following manner. Stop. The Tehsildar in the writ petition, see one thing, the respondent number 1 is Tehsildar Port Blair and the application is before the Tehsildar South Andaman. Is it the same?
Same one.
The Tehsildar Port Blair, being the respondent number 1 herein, is directed to consider the representation filed by the petitioner on 11th August 2023 in accordance with the prevailing rules, after giving opportunity of hearing to the petitioner as well as the private respondent, and pass a reasoned order and communicate the same to the parties. Stop. the Tehsildar is directed to cause a spot inspection upon prior notice to both the parties to ascertain the nature and extent of unauthorized construction as alleged, and to further ascertain as to whether the construction is being made over government land. Stop. Next paragraph. The Tehsildar shall ensure that no private party is permitted to raise any construction over government plot of land. Stop. Next. The Tehsildar shall cause spot inspection upon notice within a fortnight from the date of communication of this order, and forward the spot inspection report to both the parties. Stop. An opportunity of hearing shall be given by the Tehsildar, and a final order shall be passed within a period of 4 weeks thereafter. Stop. Next. Till the matter is finally disposed of by the Tehsildar, no unauthorized construction shall be made over the government plot of land. Paragraph. Learned advocate for the petitioner is directed to forward a copy of the representation dated 11th August 2023, along with all documents in support of her allegation to the aforesaid respondent at the time of communicating the order of the court. Writ petition disposed.
Deeply obliging.
Service is taken on record.
Oblige, Your Lordship.
Item number 9, WPA 900 of 2023.
Your Lordship, I am for the petitioner here, petitioner's Your Lordship. Petitioner number 1 is the wife, petitioner number 2 is the daughter, and petitioner number 3 is the son-in-law of one Pandian. Now that Pandian, he had a landed property here where house has been constructed. It is the case of the petitioner number 2 and 3 that they have constructed with their own money. I'm not going into all those things, Your Lordship. Now being the service is their Lordship. I have filed.
I'm appealing for the authorities.
Because I am
Private
challenging the order dated 11th August, which is going to be implemented within 15 days. And tomorrow is the last day of the circuit, and 15 days will expire within that time.
And it is this Pandian
Yes.
land. Who is the
Yes.
private respondent?
Yes.
Same person.
Same person. Pandian is the person who is the owner of the land.
And he is not aggrieved.
He is aggrieved. He filed an application. He is a senior citizen. He filed an application.
But then you have implemented him as a respondent.
Yes, Your Lordship, because we are directed to be removed.
By Pandian.
Yes, Pandian filed an application before the tribunal.
Yes.
That is the subdivision officer, that one tribunal is there, Senior Citizen Act. And there he filed an application saying that his daughter and son-in-law are occupying his landed property, and then they should be removed. An eviction order has been passed under that particular act. I'm challenging on 2
But
points,
there is a appellate provision, if I am not wrong,
but I am challenging on the.
isn't it?
Yes,
Yes,
madam.
it's there.
It is there.
I am challenging on the point of opportunity of hearing, and secondly on jurisdiction also, both the things. No opportunity has been given. No,
But why don't you take it up in appeal?
Your
No
Lordship,
opportunity was given.
let me
They have participated in the
let me
proceedings.
complete, Your Lordship. Notices were
It is a senior citizen matter. I am not going to interfere.
Your Lordship, kindly.
My lord.
Your Lordship, what would be the position of writ petition number 1? She's the wife. And DV Act petition is
If-
pending.
If the,
I have a decision of the Honorable Supreme Court in that line.
maybe, but then if the wife is not in good terms with the husband,
No,
Possibly there is-
he is doing gambling, Your Lordship. All properties at mainland has been sold. That I have written.
no,
in the-
it's better
No,
you
let-
serve and come.
Let me complete, Your Lordship, because tomorrow is the last day and 15 days will expire, Your Lordship. I will not get the next circuit. Kindly consider, your
In
lordship.
the meantime, we apply before the appellate forum.
Appellate forum, there is no question, your lordship, because appellate forum, let me complete, your lordship. I will satisfy this honorable court that opportunity of hearing has not been given to me. I will satisfy, your lordship. And as per chapter 5 of the Senior Citizens Act, there is no jurisdiction upon the tribunal to pass an eviction order. Kindly consider, your lordship. I'm
But
just
this
sure.
jurisdiction issue has been decided by the Honorable Division Bench of this Honorable Court.
I have the
This is
decision of
the-
Honorable Supreme Court in that line. I got that. No.
It is better you stop. There is no-
Lordship.
There is no,
Be complete here.
there is no proof.
Lordship.
Let me see your affidavit of service once.
Yes. I filed, your lordship. It has been sent on 21st August to the address given by him in the before the subdivision officer. You see, once the order is
Sent.
implemented, what will remain in my writ petition, your lordship? Nothing will remain.
Matrimonial proceedings pending.
Yes, DV Act petition is pending, your lordship. Your lordship, let me complete.
No, no.
Your lordship, I can pass the order. Kindly, your lordship, I am the sufferer, your lordship.
Yes.
Kindly grant me opportunity so that I can make my submission. Your lordship, these, first we have to see, your lordship, as per chapter 5 of the Maintenance of Welfare, Senior Citizen Act, whether the tribunal has got any jurisdiction to pass an eviction order. That may be looked into here, your lordship. The Senior Citizen Act, your lordship, says, and I have the decision of the Honorable Supreme Court also the same line, no order of eviction can be passed. Your lordship, chapter 5 deals with, your lordship, the state government shall take all measure to ensure that the provisions of this act are given wide publicity through public media, including television, radio, and print. Then the central government, state government officer, including the police officers and members of judicial service, are given periodic sanitization and awareness training on the issues relating to this act. Then, your lordship, the effective coordination between the services provided by the concerned ministries or department dealing with the law. Then 22. The state government may confer such powers and impose such duties on a district magistrate as may be necessary to ensure that provisions of this act are properly carried out, and the district magistrate may specify the officer subordinate to him who shall exercise all or any of the powers and perform all or any of the duties so conferred or imposed, and the local limits within which such powers or duties shall be carried out by the officer as we prescribe. Now, the state government shall prescribe a comprehensive action plan for providing protection of life and property of citizens, senior citizens. Where any senior citizen who, after the commencement of this act, has transferred by way of gift, this is a different thing. 23, 2, 1 and 2 are different things. Now, the only thing is that, your lordship, 22, clause 2. The state government shall prescribe a comprehensive action plan for providing protection of life and property of senior citizens. Now, even in terms of the rules, your lordship, which is there, along with the act, the authorities, that is Andaman and Nicobar Islands, they have framed certain rules. Even as per the rules, your lordship, there is no provision that the children or wife can be evicted by passing such an order. And then, your lordship, what happened? I am submitting. Notice was issued to the respondent number 2 and 3. We have been approaching the authority concerned and requesting him to give the copy of the complaint to us so that we can file our objection. No copy of the complaint was given to us. And on the fine day, the order of eviction was passed. This is not the method of giving opportunity of hearing, lordship. Law is settled. Adequate opportunity of hearing should be given. So when I am not getting the copy of the complaint, how can I file my written objection, your lordship?
No, several dates
is
were
not-
given.
Dates
They
have
have
been given.
appeared.
I have been requesting the
Appeared.
copy to give me the copy of the complaint.
Appeared through advocate also.
No, they have not. They can show it, your lordship. Their order sheet would speak that they have not given the copy of the complaint to me at any point of time.
What is the judgment that you are relying
Yes,
upon?
sir.
Please show.
This is the First, single bench judgment, it is appealed before the division bench, both the judgment I am placing. That is the division bench.
This is the decision of the Honorable Supreme Court. Your Worship. I have specifically mentioned,
Show me the act also.
yes, Your Worship.
Division bench judgment relevant page is page number 12. Second last page. Section 22 subclause 2 of the act.
The facts are completely different, Your Worship. I appear, no,
Same.
the fact is different.
Same.
There was no question of wife. Their wife is there. And decision of the Honorable Supreme
Which
Court.
provision of the law you are relying upon?
Chapter 5, Your Worship.
Chapter 5,
22
22.
clause 2. That is the provision on the basis of which they this might be the subdivision, because he has mentioned only chapter 5. So I find that it is 22.
Chapter
clause 2.
5, clause 2.
No, 22 clause 2. Second page, next page, Your Worship.
That goes to chapter 6.
Just, I'll just show. Mark it.
This is them. Yes. I am having copy. Judgment deals with the same section, 22 subclause 2.
Subclause 2. Protection of life and property of
yes.
senior citizens.
ठीक है वही वो same. आप दे दीजिए.
The state government shall prescribe a comprehensive action plan for providing for protection.
Your Lordship, this is 22 clause 2. Next page. There, Your Lordship, the state government shall prescribe a comprehensive action plan for providing protection of life and property of senior citizens.
Yes.
This has been relied upon. Where is the comprehensive plan? Under that particular plan, whether the tribunal has been given jurisdiction to pass eviction order or not, nothing is known.
Does the appellate tribunal function over here?
Your
My
Lordship,
lord,
several
Deputy Commissioner,
applications,
district
Deputy
magistrate. Yes, madam.
Deputy Commissioner is
Deputy
the appellate
It is
tribunal.
Yes, madam.
and Your Lordship may kindly see if he has given it, and under chapter 5, the action plan which is given, it is a district magistrate who has got the power, not the tribunal. Kindly see, Your Lordship. This one, Your Lordship. This, I have got the entire bunch. The
Yes,
rules
it
and
is
the action
here.
plan. Not there, Your Lordship. Subsequently, the action plans were prepared by the authorities, and district magistrate is having the authority.
See, the Tehsildar has recorded that the property is of Pandian
Yes,
and he can dispose it of or use it according to his own free will.
yes, Your Lordship.
And you are not permitting your father or your husband to enter into that house. And that is the reason he wants it for his own use. Now, what is the wrong in it?
Neither report has been given, nor complaint copy has been given, nothing has been given. The tribunal used to issue notice to us, asking us to appear there. We have been specifically pleaded in my petition. We have been asking him that you please provide the copy of the complaint to us, or whatever the document is there, kindly give it to us. Never it was given. Let him show that the copy of the complaint was ever given to us. We were not given opportunity to file our objection also. DV Act, my petition is pending.
No, DV Act is
Objection has been
different.
filed.
Where from do you show that the objection was filed? She was heard, I can see.
Yes.
But where is the recording that the objection was filed or anything?
Copy itself has not been given. How I will file objection? The order sheet can be seen, Your Lordship. We might have brought the file.
No, I don't.
In the order sheet, it will reflect.
In the judgment dated 11th August, nothing is mentioned.
Yes, she has filed an application dated 23rd May 2023. The petitioner.
Notices were issued
Petitioner,
and
petitioner.
duly
The
served.
respondent, the respondent.
And effective hearings were conducted on 1, 2, 3, 4, 5 dates.
Yes,
on every date, Your Lordship,
Show me one petition, that you filed before the tribunal with a prayer to serve copy of the complaint upon you.
They attended personally, Your Lordship. So they have no knowledge that a petition has to be filed.
Yeah.
It is a duty of the authority to provide me the copy of the complaint.
No, but then it appears that she took part in all the hearings.
At every hearing, Your Lordship, this was the point.
Where from does the court
I
get
have
to know that?
specifically pleaded, Your Lordship, in my writ petition, specifically pleaded that at every date I have been requesting the authority that you give the copy of the complaint, whatever is there, please give it to me. It was never given to me. That is a procedure which is to be followed. Not only that, Your Lordship, I'm showing one thing. Under the Senior Citizens Act also, if this particular person, as the tribunal is taking steps, they have to follow the procedure of civil procedure. So they have to give the copy to me. Because it's a summary eviction proceedings. And Supreme Court decision I have already rendered, Your Lordship.
What does the Supreme Court say?
Supreme Court says, Your Lordship, that
Which portion?
yes, I've given the copy. Your Lordship, I will just 2 seconds it will be given, Your Lordship, I will just mark it.
This order is passed under Article 142 of the Constitution.
Protection may have been given under Article 142, Your Lordship. The principle which is mentioned, Your Lordship, that in a summary proceeding, summary eviction proceeding, Your Lordship, share household cannot be taken away.
Please come. The petitioner number 1 is the wife. Petitioner number 2, the daughter, and petitioner number 3, the son-in-law of the respondent number 2. Stop. Paragraph. The respondent number 2 approached the Senior Citizen Welfare and Maintenance Tribunal, South Andaman, under the provisions of the Senior Citizens Welfare and Maintenance Tribunal, under the Maintenance and Welfare of Parents and Senior Citizens Act, 2007, with allegation that the private respondents were not permitting him to enter into his own property despite multiple requests. Stop.
Sorry for the interference, Your Lordship. I have specifically mentioned in my writ petition that there are two rooms in the house. One room is occupied by the private respondent and writ petition number 1. Another, Your Lordship, by the daughter and the son-in-law. That way they were living. I have never restrained.
The paragraph, the tribunal, on receipt of the petition from the respondent number 2, issued notice of hearing upon the petitioner's hearing.
Only to 2 and 3, not to 1, Your Lordship. No notice to 1.
Stop. Next. The but then the order is upon the 2 and 3 only. There is no order upon 1.
1, there is no order.
So why is 1 so bothered?
Because, Your Lordship, she is taken care by these her daughter. She is also a senior citizen.
Daughter is also senior citizen.
No. Mother is senior citizen.
Mother,
And
there
that-
is no order upon the mother.
Yes, Your Lordship, but she is not of good health. She is taken care of by the daughter only. If the daughter is removed from the premises, then she will be living.
The daughter and the son-in-law has taken control over the mother, that is the petitioner number 1, and doing all these things
No, Your
to
Lordship.
throw away the
No, Your Lordship.
private
Let
respondent.
it be ordered, Your Lordship, that we will not restrain the private respondent from entering into the house. Let there be an order to that effect.
No, private respondent want to dispose the
That
property.
is the intention. Now the
Yeah.
intention is coming.
He can dispose for his,
He wants to dispose of the entire property to continue with the gambling
it
activity.
is his,
So if the husband takes care of the wife, where is your difficulty?
No difficulty, but he is not taking care. He is
No, that's
have
the,
it.
that the court is there, the PW proceedings, the prevention, DV
But
proceedings,
by
everything is
that time,
there.
Your Lordship, by that time, the DB Act proceedings is completed, Your Lordship. We all will be thrown out from
You
the
can
premises.
you can obtain orders in that proceeding.
I-
Where is the protection of the daughter and the son-in-law?
There is no protection of daughter in son-in-law.
Let the son-in-law take the mother. If the son-in-law is so interested to take care of the mother-in-law, let the son-in-law take the mother-in-law to his residence and take care.
Your Lordship, these things I can very well explain before the authority concerned. But the authority has not given opportunity to me to raise all these points before.
What did I mention? Upon the petitioner numbers 2 and 3. And hearing was conducted on as many as 5 occasions. Stop. It appears from the order passed by the tribunal that the petitioner numbers 2 and 3 had submitted an undertaking in front of the SHO PS, Pahargaon on 5th August 2022 that she would vacate the subject property within a month. But despite the undertaking, she did not move out of the subject property. Stop, next. The order passed by the tribunal dated 11/14th August 2023, impugned in the instant writ petition, specifically mentions that the parties were heard stop. It further appears that the submissions of the wife was also taken into consideration. Paragraph. The tribunal was of the opinion that as the property belonged to the respondent number 2, accordingly, the respondent number 2 had the right to enjoy the property. Stop. The tribunal passed order directing the petitioner numbers 2 and 3 to vacate the property within 15 days from the order, failing which the Tehsildar shall execute the order with the assistance of SHO. Stop. The petitioner has been permitted, the respondent number 2, not the petitioner, the respondent number 2 has been permitted to enjoy his own property after it is vacated by the respondents. Paragraph. Learned advocate representing the writ petitioners submit that the aforesaid order has been passed without supplying a copy of the petition filed by the respondent number 2 before the tribunal. Stop. It has been submitted that the respondent number 2 is involved in gambling and he is in the habit of selling off his properties. Stop. There is a matrimonial dispute pending between the petitioner number 1 and the respondent number 2. Stop. The respondent number 2, with the sole intention of evicting the petitioners from the subject property, has obtained such order. Stop. The paragraph. The petitioner number 1 is a senior citizen and is being taken care of by the petitioner numbers 2 and 3. Stop. Next.
I have also one more point here also. It is a district magistrate who has got the power and not the tribunal in terms of the act and the rules.
Further submission of the petitioners is that the Tehsildar does not have any jurisdiction to pass order of eviction.
Not Tehsildar, it is tribunal. It's a tribunal who has passed, not
Very well. The tribunal does not have the jurisdiction to pass order of eviction, and it is the jurisdiction of the district magistrate to pass such orders.
And first notice was issued by district magistrate only.
Where is that?
Page number 20.
daughter and son-in-law. All allegation against the daughter and son-in-law. The petitioners rely upon the order passed by the Honorable Supreme Court in the matter of SMT.S Vanitha, Vanitha versus the Deputy Commissioner, Bengaluru Urban District and others. Reported in AIRSC 177. That an order of eviction cannot be passed in exercise of the summary powers entrusted by the Senior Citizens Act 2007. Not the order of eviction, but the claim to remain in shared household cannot be obviated by passing order of eviction in exercise of the summary powers entrusted under the Senior Citizens Act 2007. Paragraph. Prayer has been made for setting aside the impugned order passed by the tribunal. Paragraph. None appears on behalf of the respondent number 2. Stop. Next. There is no proof of service of the writ petition upon the respondent number 2. Stop. The affidavit of service shows that the writ petition was posted on 21st August 2023. Stop. Paragraph. On a perusal of the impugned judgment passed by the tribunal, it appears that the proceeding was continuing against the petitioner numbers 2 and 3. Stop. Next. Though the petitioner number 1 also approached the tribunal with an application but there is no order passed by the tribunal for evicting, tribunal against the petitioner number 1, either for evicting her or directing her to vacate the property. Stop. Paragraph. It appears that orders have been passed, not orders, order has been passed directing the respondent numbers, directing the petitioner numbers 2 and 3 to vacate the property. Stop. Next. The apprehension of the petitioners that the wife, that is the petitioner number 1, may also be evicted appears to be unfounded. Stop. There is no order directing the petitioner number 1 to vacate the property. Stop. Next. The petitioner numbers 2 and 3 are the married daughter and son-in-law of the respondent number 2. Stop. The petitioners contend that the petitioner numbers 2 and 3 take care of the petitioner number 1, who is a senior citizen. Stop. Next. It has been submitted that the property has two rooms, one of which is occupied by the petitioner number 1 and the respondent number 2, and the other is used by the petitioner numbers 2 and 3. Stop. The petitioners undertake before this court that they will permit the respondent number 2 to use his property, and the respondent number 2 will not be restrained by the petitioners from entering into his own property. Stop. Next. Paragraph, as it has been submitted that the petitioner number 1 is taken care of by the petitioner numbers 2 and 3. It will be open for the petitioner numbers 2 and 3 to take care of the petitioner number 1. But it is not necessarily that the petitioner numbers 2 and 3 are required to stay in the same property for the purpose of taking care of the petitioner number 1. Stop. Next. It will be open for the petitioner numbers 2 and 3 to visit the petitioner number 1 for taking care of her. Stop. Paragraph. The order impugned is accordingly not interfered with at this stage. Stop. It will be open for the aggrieved party to approach the appropriate forum for obtaining relief. Stop. The writ petition stands disposed of.
Your Lordship, this only.
Oblige,
Your
Lordship.
Lordship, if application is filed before the appellate forum, the appellate forum be directed to dispose it of along with the
See,
same.
the baby has not yet born. How can the court direct to dispose it of so soon?
Problem is that, Your Lordship, when we are filing also stay application, it is just remain pending, Your Lordship. They're not.
If it is not disposed of, then you know what is to be done.
Actually, the gap between the circuit is so much, Your Lordship, that everything is done by the authorities between that.
Previously, one circuit in every month was there. Then there was a request from the bar to reduce the number of circuits.
That should not have.
Online is.
I do not know.
Online.
You'll again request so that the number of the frequency of circuits increase. It will increase.
So many matters are now pending. Apply.
Item number 901 of 2023.
My lord, I am appealing for the petitioner. My lord, this is that matter, the petitioner claimed death certificate. In the private respondent, there is objection.
Who is the
But-
private respondent?
Private is another person, Sajida Begum. She said, I am the second wife
Okay.
of the deceased. The problem is that there is a outstanding dues before the bank, the loan obtained by my deceased husband, and that is pending. Bank.
Where is the service upon this,
My
Sajida?
lord, the service is not completed to the private respondent.
Bank
Not
also
complete.
there. Bank also has to be served.
Then please serve. Service not complete.
Personally, I have served to the bank.
Service not complete, list in the next circuit, service in the meantime.
Item number 11, WPA 902 of Contract 3.
Yeah, my lord, same position, service to the
Okay.
respondent, 1 and 3 is not complete.
Very well, same
I have
one.
my lords, in item 11, my lords, I have a preliminary objection to maintainability, my lords.
Raise it on the next occasion.
I'm appearing for revenue department in this matter.
Very well, make your submissions when it is taken up for consideration.
My lord.
Item number 12, WPA 904 of Contract 3.
Lordship, my opinion, Mr. Kevni Japal appears on the side of the petitioner. Kindly give a short class over as one senior as like before court number 2.
I'm appearing for the respondent authorities, ma'am.
Cannot help, it will go to the next circuit. Accommodation has been sought for. On behalf of the learned advocate representing the petitioner, stop. List the matter in the next circuit. Record your appearance.
My lord. Oblige, lord, sir.
Item number 13, WPA 907 of Contract 3.
I'm appearing for the petition.
I'm appearing for the respondent.
Petitioner along with the other four tenants had applied for the subdivision before the deputy commissioner, madam. And a proposal map was also supplied, madam. It was given in the month of February 2020.
It is pending consideration till date.
But thereafter, they have given several queries they have made, stating that my map, proposal map, that is a consented proposal map, that is not tallying with that map. But I am a layman. They should prepare a map as per their record.
I see there is a notice issued to you on 4th of April directing you to appear. Did you appear?
I was preparing in each and every notice, my lord. Each and every.
And
notice
no final order has been passed.
Not passed. Stating that, kindly see, my lord, in the notice, they are, now they are saying in the northern part, it is not matching with my proposal. I am a layman, my lord.
Where, which portion?
My lord, all the notices start from,
I come to the last one, page
Last-
28, 4th
last
April.
year, my lord. It's a-
Measurement does
the
not tally.
measurement of northeast side of the proposal map. I am a layman. The deputy commissioner has the machinery. They have the survey. They have, I have already given the proposal map. I've given the proposal area, everything. They should prepare the map and it can be done, my lord. It can be done, my lord. If it is area is shortage or something like that, because they are concerned. If they are
What is your
preparing,
submission?
they are ready to.
If the possession is not there, there is a shortage of land, then
Provision is not there.
possession.
Possession is not there.
Consented, all parties are agreeing for the, what they have given the map. All parties have signed.
But then there is
There is
no,
no dispute.
no, but then there is only one petitioner and no private respondent. Who are the other parties?
Yes. So that they have, along with the petitioner, they have given the,
Where?
application for subdivision. My lord, kindly come to my page, first, my lord, kindly come to my page 16, my lord. Kindly come, my lord. Along with the petitioner, the other co-tenants also given the application to the deputy commissioner. This is the 16, page number 16, my lord, for subdivision.
But writ petition is one.
And kindly come to page 18, my lord, this is the proposal.
Please take down.
It is still pending. If they are calling, my lord, all the petitioners, along with the petitioner, other co-tenants, they are agreeing for this. That's why they have signed. Together they have signed and they have.
The petitioners along with all other co-tenants of the subject property seek for subdivision of the land.
My lord.
Stop. Prayer was made before the deputy commissioner way back in the year 2020. The same is yet to be finally disposed of. Stop. It appears that the matter was taken up for consideration by the authority, but final order could not be passed in view of certain discrepancy that has been found. Stop. Paragraph. Learned advocate for the petitioner submits that the petitioner and the other co-tenants all are laymen and they are not aware of the not aware of all the provisions of law and the manner in accordance with which the map is required to be prepared. Stop. The proposal map appears to have been prepared by the petitioner and the other co-tenants without taking any professional help. Stop. Paragraph. The respondent authority issued notice of hearing on several occasions to all the necessary parties. Stop. The petitioner contends that the petitioner was duly represented on all the dates of hearing. Stop. The co-tenants are also agreeable for the subdivision to be made. Stop. Next paragraph. From the submission made on behalf of the parties and upon perusal of the materials on record, it appears that the act of subdivision, that the subdivision could not be effected on account of discrepancy in the proposal map submitted by the parties. Stop. Next. The concerned authority is directed to take steps for removal of the discrepancy. No, the concerned authority is directed to advise the petitioner and the other co-applicants the manner in which the discrepancy may be removed, so that the subdivision as prayed for may be effected.
But the authority itself can do it, madam.
Stop. If required, the authority may prepare a map according to which the subdivision proposal may be acted upon. Stop. Next. An opportunity of hearing shall be given to all the necessary parties. Stop. A final order shall be passed in the matter at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. Learned advocate for the petitioner is directed to forward the copy of the proposal map along with all other documents in support of the prayer for subdivision to the respondent authority at the time of communicating the order of the court. Who is the authority? The deputy commissioner? When the assistant commissioner all along issued the.
Even he has given several representation, he has several notices he has given.
Yes.
The competent person is the deputy commissioner.
Then mention the deputy commissioner shall take a decision. Read petition disposed.
Obliged.
Obliged, Lord.
Number 14, Rahul PA 910.23.
I am there for the petition. So,
14 and 15 are similar
No,
matters?
no.
Different.
I will be appearing
Sir?
for the respondent.
yes,
Authority.
Any private respondent there?
no,
What is it?
not under the Notaries Act 1952.
Are you ready with instructions,
No,
Mr. Shivabalan?
No, my lord, I am not. I do not have the copy since it is.
You don't have the
District-
copy?
No, my lord.
Here is for the respondent.
No, he has
Yeah.
instruction to appear, but copy is yet to be received.
Yes.
Please take down.
Hmm.
Learned advocate representing the respondent authority is yet to receive a copy from his client. Stop. Next. Will you serve a copy or should you?
I will do it now. So if it is taken up tomorrow, I will do it now. So if it is coming in the next circuit, then I'm taking back. now.
Then take it back.
I am taking back. now. Yes.
I will give it. I will give it after.
You can make a photocopy on your own and return the plan to him.
Yes.
Let it be. I will stuck up.
Let the matter appear before the next circuit. Stop. Learned advocate for the respondent shall take necessary instruction in the matter.
Obliged, Your Worship.
Next one is also same.
No, here there are private respondent, Your Worship.
Here I
That's
prefer
not for
number 1, 2, 1,
implementation
3.
of the order, my lord.
Do you have a copy?
I have a copy. 1, 2, 1, 3. I am a.
Private respondent has been served
It is simply being dispatched, Your Worship.
and service is not
It may
complete.
take time.
Service is not complete.
Well, may I say one thing?
Yes.
I have sought for implementation before the Tahsildar who passes the order, the private respondent was a party. It's subject to what my lord says. If an order is passed back to the Tahsildar to implement in his presence, that would.
That is a civil dispute, civil case is pending.
No, I'm coming to that. I'll come. That's with
Civil
regard to
case
some
is
other,
pending.
that's with regard to some other property.
No,
For
no,
the
same.
property, no. You need
You have
to check the
mentioned
schedule.
this in page number 62.
I have mentioned, it's my edit, I know I am mentioned. I'm not been filed it blindly, I know everything. But kindly come to page 62.
Yes.
But kindly see the schedule of the suit land.
Yes.
It's the land claimed is 55A at page 68, 5A/1/11. Not the order of the Tahsildar I'll show is pertaining to my land. I'll show that order. My lord kindly turns to the order of the Tahsildar. It's at page,
50A/1/7.
yes, I'm the recorded owner. And there are orders of these code.
5A/1/7.
There are previous orders of these code directing the Tahsildar to execute it. Not, I'll show that order. Nothing was done.
March 2023.
But kindly see page 54, the first order of this code. Tahsildar was that. Again, the Tahsildar passed this order at page 59. I want implementation in respect of my property. Even if suit is there, even if there is an injunction on that pertains to the scheduled property, which is confined to the land of the private, I'm not concerned with it. I'm concerned with the land which I own.
It is a
Which is
private.
record.
And this order dated 29th March has not been appealed against.
No,
Please take down.
no.
The petitioner seeks implementation of the order dated 29th March 2023, passed by the Tahsildar, Port Blair. Allegedly in compliance of the direction passed by this court in WP number 065 of 2019. On 25th March 2019. Stop. Next.
Lordship, this order is the subject in the civil suit. This order is mentioned. Only private respondent can bring light to the whether it has been challenged or not.
1 minute.
Suit is concerned with the
Kindly
land
see.
which has been scheduled.
Can you see page number 66?
I just failed to understand why the authority was passed order supporting the private respondent. I just felt, what is the stand being taken before the report?
Private respondent
On one hand passes an order,
Is it-
seek for implementation to support the private respondent.
private respondent is the person who can bring light.
Why you support, I just failed to
We
understand.
have not served.
Service is done, I know that thing. Why the private respondent supported, you passes an order in respect of my property.
The said order was passed upon hearing all the necessary parties. Paragraph, direction was passed by the Tahsildar to remove the illegal occupation over an area of 0.0017 hectares out of the land bearing survey number 5A1/7, measuring total area 0.0055 hectares, situated at Hado village, recorded in favor of the petitioner Sri M. Raja Rao,
Hello.
son of Simadri, on or before 2nd April 2023. Failing which, the Revenue Inspector's Circle number 2 will take steps for removal on 3rd April 2023. Stop. Next paragraph. It has been submitted by the learned advocate representing the petitioner that the said order has not been appealed against by any party till date. Stop. Next. Paragraph, there is no proof of service of the writ petition upon the private respondent. Stop. Next. In view of the, is there any affidavit of service?
I can bring this lordship, this paper I can bring by way of an affidavit.
Please file your affidavit in course of today.
In course of today.
When did you post?
2 days ago, 48 hours lapsed. Lordship.
2 days.
My lord.
The
Or my lord, nothing can be done, let this be taken up tomorrow. Because this has been dispatched. I say, my lordship, even the Tahsildar before executing, because this is being done under the local regulation. He would give a formal notice to the private respondent that we are going to implement this order on this particular day, it can be done.
there is no proof of service. Stop. The learned advocate for the petitioner is granted leave to file affidavit of service in the course of the day. Stop. Paragraph. In view of the order that I propose to pass, the private respondent will not be aggrieved in any manner whatsoever. Stop. Next. There is nothing on record to suggest that the order dated 29th March 2023 has been varied, vacated, set aside or modified by any competent forum. Stop. The said order has attained finality by now. Stop. Next. In view of the above, the Tahsildar is directed to take steps for implementing the order dated 29th March 2023. Upon giving opportunity to the private respondent to remove from illegal occupation over the subject land. Stop. Next. The submission made on behalf of the learned advocate representing the official respondent is taken note of that a title suit is pending consideration between the parties. Stop. On a perusal of the schedule mentioned in the plaint of the pending suit, it appears that the suit plot which is involved in the title suit is different from the subject plot over which order has been passed by the Tahsildar. Stop. Next. Accordingly, the suit is no way connected with the subject plot involved in the present writ petition. Stop. The writ petition stands disposed of.
I'm grateful.
Obliged, Lordship.
Would you all like to take some break?
Yes.
Yes, sir.
I don't know, 2021 can be taken up.
Yes, my lord, I also require the same mistake has been made, my lords, in these two matters.
Mistake?
My lords, that earlier, my lords, that spot inspection, my lords. I heard that
Which
my-
one? I'll come back. It is for you all if you all want a break.
No, my lord, 3 PM, there is a contempt matter fixed in the principal bench, my lord. That's why I am requesting, my lord,
Very-
20 and 21.
Then we can call it serially.
Number 16.
Lordship, I intimated Ms. Renu for extension of time, this matter is for.
Extension of time for?
Honorable single judge, while disposing of my appeal, granted liberty me to file appropriate proceeding before the appropriate forum against the offending vehicle owner for claiming the amount paid to the claimants.
Let me see the
time was
file once.
Short time.
Let me see the file once.
Can application.
Yes, I can see. But then where is the respondent?
Inner page 2, Miss Zinu is there for,
Where is she?
I intimate here and a copy was also served. She
Copy was also served. Show me the service.
she is the receipt on my copy.
The petition to the office of Plan 3 in accordance with the law.
Inner page 2, last paragraph.
February 23, the order was passed. And you filed it in July 2023.
No, Lordship, it was filed in the month of March itself, 15 March 2023, but it is listing now. So my embargo is if I go to file appeal, there is a time limit fixed by this.
Obviously,
That's
but
why-
then can 3 is filed in can 3 is filed when?
On 14 March 2023.
March to be listed in July, you say?
It was in the Philip form, the form which is to be filled up. It was mentioned to be listed on 15/3, but it was not listed. Then I went to the office, they said it is not listed, you change the date. So date was changed. But it was filed.
From March to July,
Yes, Your Lord.
there
It was
she is
never
from.
listed.
What will be your submission?
Lordship, I believe the prayer is not against me.
Not against you.
Not against me.
So you do not have a problem.
And as a
Yes, yes. Only to file proceeding against the owner, I want to extension of time.
Can 3/2023 has been filed. By the insurance company
Insurance.
seeking extension of time to take steps in accordance with the direction passed by this court on 16th February 2023. Stop, next. The court directed 4 weeks' time. The court granted 4 weeks' time. From the date of the order. For filing the said petition. Stop, next. According to the applicant, comma, the time granted was too short. And accordingly, prayer has been made by filing the instant application on 14th March 2023, seeking extension of time to file the petition. Stop, next. Paragraph. Who are you representing?
I'm representing the claimant.
Learned advocate representing the claimants do not have any objection to the prayer made by the applicant. Stop, next. Accordingly, the insurance company is granted leave to file appropriate proceeding in accordance with law within a period of 4 weeks from date. Stop. The application stands disposed of.
Okay.
Item 17.
Your Lordship, in this matter, learned counsel Mr. Sabir is appearing, Your Lordship. I pray for not to do
Is Mr. Sabir appearing for the applicants?
applicant.
On the prayer of the learned advocate representing the applicant, comma, let the matter stand over till the next circuit.
Item number 18, your worship, this is the same matter, bunch of matters was there, your worship, where I filed the CAD application for extension of time.
STA,
So same order, your worship.
give me the order. Have you given the order?
I'll just mention,
Please,
17th August, the order was passed.
17th August, take a passing, very well disposed.
Obligation.
Final order not been passed,
No, no,
No, no.
it's under process.
Under process.
still under process. Very well.
Item number 19.
Was this matter, my lords, was for, this is that matter, of the
yes,
facilitation
it is.
council.
It is.
My hearing is concluded.
Hearing is concluded.
My lords, orders are reserved. ma'am.
No, no, I am delivering our judgment
Oh,
just
well.
now. It has been prepared. The interim resolution has been set aside
My lord,
and the council has been directed to either take up the dispute for arbitration itself
my lord,
or to refer the same to any institution or center providing alternate dispute resolution services for arbitration of the dispute.
my lord.
The provisions of the Arbitration and the Conciliation Act 1996 shall be applicable and the writ petition is disposed of.
Your lordship, just one minor submission. If the council is referring the matter to some arbitral institution providing arbitration, the provisions of MSME, the ED Act should also be applicable because
Yes,
I am
yes.
eligible for the.
Yes.
Yes, so
Right. It will be applicable. That has been mentioned.
obliged.
My lord.
Grateful you.
Item number 20.
My lords, 20,
Yes, 2023.
my lords, there was a direction to carry out spot inspection.
Yes. Has it been
And
done
it was done, but same mistake, my lord, there.
without notice?
Yes, my lord, they will be.
Here was not-
Yes, yes.
Yeah, he admits that there was a
Admitting
mistake.
that, my lord, we will carry it out.
Petitioner is in the middle and in 769 and 772, both are in the both sides. And the municipal council cannot serve a notice to the petitioner. That is the very unfortunate part. And there are another aspect, Your Honor, from the first time, from their affidavit, I can come to know.
Whose affidavit?
769,
Whose affidavit?
the affidavit filed by the engineer,
All right.
which is required to be again re-inspected.
It will be re-inspected.
The schedule of the property.
Yes.
And your lordship, why the case was filed against Kupabai? This even today morning also, this is different. Today morning also from the common service center, we have taken out, it is still recorded in the, from the website. This timing is also there today morning. That is the reason which petition is being filed against Kupabai. But the documents they have made is otherwise. This morning it's taken out. From the common
Yes.
service.
What is otherwise? I can see Kurupabai,
Yes, that is there,
Nirmala,
but their affidavit,
Nagamani,
their
Vijay
affidavit-
Kumari. It is the same document.
Yes, yes.
Avadi 3073. Household site.
But-
It is the same thing.
It was not there, your lordship, when the writ petition was filed. I'm just placing.
My lords, we'll carry out a fresh inspection, my lord.
Yes, but
We'll
that
carry
should-
out, my lord, this report
that
anyway.
should be ascertained that who is doing the alleged construction. Out of these three, now they are coming up with three. Kindly see, this is the document. While filing, we have obtained from the website.
What?
The only Kupabai is there.
Where did the others go? Nirmala, Nagamani and Vijay Kumari?
Others were not there
No, because it
at
is,
that point of time.
it is transferred to
It
the.
was
three
conveyed,
lords, my
bro.
lord.
I'm for the private respondent Krupabai.
Huh.
Mother is the Krupabai.
Mother is
She
the
has
Kurupabai.
conveyed by virtue of a conveyance deed in favor of three daughters.
All right.
Records were corrected. I'm having the updated records.
So Kurupabai is no longer there. It has been transferred.
He is also there.
To some,
Maybe in the records, her name ought not to be there because it has been conveyed and
Yes.
transferred in favor of the daughters.
I'm having the deed.
But no, no, it is not conveyed in entirety, my lords. It is like.
Portion.
The entire land is of Kurupabai.
Now Rupabai resides in one plot,
Huh?
3 plots she have transferred to 3 daughters. Only one daughter is in violation, that what
Is in violation.
No, under the municipal regulation,
No, we are not.
plan is required to be obtained, my lord, plan is required to be obtained in respect of a portion of building which is exceeding 50 square meter. The daughter who has been conveyed with 50 square meter is raising work. It is within the limit, also the regulation.
Well, please,
One subdivision, madam, and the petitioner kindly given opportunity, madam. But the construction is made about
No.
300 square meter. That is my allegation. So let the inspection also again made.
Yes, it is inspection.
And another aspect is left over. Madam, there is a LR. There
by
is
order dated 17th August
whole exercise.
2023,
Whole exercise will do.
comma,
No problem.
the municipal council was directed to cause a spot inspection upon giving notice to all the parties. Stuff, paragraph. Learned advocate representing the municipal council submits that the spot inspection was conducted. However, notice could not be served upon all the parties. Stuff. Prayer has been made directing, prayer has been made seeking permission for conducting fresh spot inspection upon notice to all the parties.
Another aspect is left over. Kindly give me an opportunity. Page 34, Deputy Commissioner has to draw another proceeding that is with respect to 165 1A of the LR. That order.
This is a matter of petition.
Kindly, this is my petition. Let me take the pains.
Yes, yes.
Madam, kindly come to page 34 of the.
Now, what you want to tell me?
That another proceeding has to be done as per LR. Rule 165 1.
For what purpose?
For setback purpose, because they are
Setback.
enclosed into our
Did you apply for before the
Yes, yes.
authority seeking
setback 34
page 34?
of the writ petition.
But then setback and illegal construction, two are different.
That is, building, as per illegal construction, whether approved plan is there, or violation is there, that means what is to look up.
Yes.
But with respect to 165 1A.
Well, you will tag up all the prayers in one writ petition.
Representation.
I don't have instructions for the
So
revenue in this.
No.
Let them
Party with the same land, both the parties are same.
The parties are the same, but the cause of action is different, isn't it?
Order to rule to is, why not
The cause of action is
Yes,
different.
cause of
separate, same property, why not?
Property is the same.
Given representation also.
All said and done. This is, the first day submission was that illegal construction is going on. Right?
It is there in the writ
How
petition
can-
itself.
two separate reliefs are being sought from two different respondents. How can this be?
The, in one petition, you seek a prayer for a direction upon the authorities to see whether any illegal construction has been made or not. And the other is, you seek setback. Right?
That setback is also part of the building bylaw as well as the.
Maybe, but then both cannot be done in one petition. You cannot pay for everything in one petition to consider and dispose of the representation. And then if the nature of the prayers are such that they cannot be acted upon by one single party,
My lord.
then
That is my lord's most significant, my lord.
Statutory authority.
No, how?
there may be so many statutory authorities. Isn't it? So can you, I'll give you leave, you take out another petition regarding setback. I'll give you leave. Otherwise, you cannot file that petition also. Yes, spot inspection. Yes, paragraph. In view of the aforesaid submission made on behalf of the respondent council. Is it council? Yes, council, comma. The concerned engineer is directed to cause fresh spot inspection upon proper notice to all the necessary parties within a fortnight from date.
Ma'am.
Stop. Copy of the spot inspection report shall be forwarded to all the parties. Stop. Next. an opportunity of hearing shall be given to all the parties. And in the event, it appears that any unauthorized construction has been carried out, comma, then necessary steps to deal with such unauthorized construction shall be taken by the Port Blair Municipal Council in accordance with law. Stop. A final order shall be passed in the matter at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Paragraph. The Port Blair Municipal Council is directed to ensure that no unauthorized construction takes place at the subject premises. Stop. So nothing remains in the writ petition. It can be disposed of.
After the previous order passed by this, your lordship, then only the work was stopped.
Now you are happy that it is stopped at first.
But I don't know whether after 25th what will happen, because they are in connivance. I am specifically alleged.
Contempt.
There are 2 CAD applications also.
Contempt. The writ petition stands disposed of. Paragraph. Leave is granted to the petitioners to take out appropriate proceedings seeking setback of the what?
Rule 165 1A violation of.
Setback in terms of rule 165
1A
1A
of the LRL.
of the this regulation. Very well. Yes, certainly. Why? Maybe it will certainly be marked. Take back all these documents that you handed over.
WP 77 is the next matter.
Please return these documents. 770, it is the same thing.
Sorry, Mr. My learned senior, Mr. Balance.
Same thing. Same.
Then
The petitioner, the inspection was.
very well, same order may be passed.
Same order.
Here also there is a prayer for setback.
Same.
Why 2 writ petitions?
2 are both separate parties. 2 different.
Or 2 different private parties.
Side, another one is in.
All right. The writ petition along with the connected application stands disposed of.
Obliged, Lordship.
Which matter?
770.
Please record your appearance.
Yes.
They are also.
So no further matter now?
No.
But this matter also I'll be seeking for a liberty to.
Same order.
Same order.
Same order.
Passed.
Obliged.
There is a matter fixed at 3.
My lordship.
So we'll sit at 3. Or 3:05, something like that. So. Lunch. After a lunch. How long will you all take? 10-15 minutes, not more than that. Very well. In that case, 3:15 will sit.
Also taking lunch.
I am a very frugal eater. Yes.
On the administrative side, this election was obstructing any submission. Now there is no COVID. The windows have been taken off. Why these are not?
But then it is only one.
Sometimes creates an obstruction while making argument.
No, just move yourself, because you never know when COVID is going to recur again and the barriers can be put in. If it is taken out.
No time it can be again.
One pillar in the middle one can be removed.
See, the camera is over here.
Camera that.
Live streaming is going on.
Oh, that pillar.
You are required to be shown on screen. Wait for some more time. Over there in the principal bench, it is the same thing. See, the screen has been taken off, but the columns are still here. Wait for some more time. Let's pray it does not recur and it will be taken off.